Good morning to everyone. We haven't heard the bells yet, but everybody seems ready to go. So let's start. We have received the notice that Mr. Dean will be available at 4 o'clock this afternoon, so that should work out well. Is there anything we need to raise before we start on the claimant side?
Nothing on the claimant side.
No, excellent. Then, good morning, Mr. Milosevic. Thank you for being with us today. I understand you will testify in English, is that right?
Yes, Madam President, this is right.
You are Milos Milosevic?
Yes.
And you're in private practice after having been a judge.
Yes, at the moment I am.
At university, you're a partner of the law firm Insignificant.
Yes, I am.
And you have given us 3 reports, one of the 16th January 2019, the 3rd October 2019, and the 5th of March 2020. Is that right?
Yes, that is correct, Madam President.
And I understand you have them there.
Yeah, I have them with me.
Good. So I will ask you to read the expert declaration into the record as you're under duty to make only statements in accordance with your sincere belief, please.
Yes, I will. I solemnly declare upon my honor and consciousness that my statement will be in accordance with my sincere belief.
Fine. I will turn first to the Claimants Council for direct question. Mr. Bekash.
Yeah, thank you, Madam President. Mr. Milosevic, good morning.
Good morning.
In the previous days, we heard about provisions on pledge of shares of privatized companies that were introduced in the 2014 law on privatization. Could you please comment on these then new provisions?
May I see provision, please?
Yes, this is document CE 223, the law on privatization enacted in 2014, and the respective provision is in Article 37.
Which one in particular are you referring to? Sorry.
Yeah, this is 37 subparagraphs 6 and 7. It starts with on the date of certification.
Just a second, please. Okay. Well, this is change of the method of establishing a pledge on shares. It was back in 2005. It was by the agreement of the parties, and in 2014, this law introduced the establishment of the pledge ex lege. However, just a second, on the date of certification of the agreement, the agency shall acquire a pledge. So this is connected to the date of certification of the agreement of sale of the capital, which is certification is the moment of the conclusion of the agreement of sale, because in the law, 2014 law, as I remember, it was concluded when it is certified. So, however, it's the date of certification or the date of conclusion when the ex lege pledge is established. But it cannot be retroactively applied to this particular privatization agreement, if that is what you are asking me. If this is applicable, it is not applicable to the privatization, to BD Agro privatization agreement, this provision.
Thank you. Mr. Milosevic, assuming that the buyer breached Article 534 of the privatization agreement in 2010, could the privatization agency terminate the privatization agreement in 2015 despite payment of the full purchase price in April 2011?
No, it could not terminate it in 2015 because the payment of the purchase price was the last main obligation for the privatization agreement. With the payment of purchase price, the last positive obligation was performed, and the term of all negative obligations has been expired at that moment. So it could not be terminated for the breach of the Article 534 in 2015. That is after the payment of the full purchase price. If that answers your question.
Mr. Milosevic, are you aware of any decision of a Serbian court that would opine on the character of the privatization agency's termination notice and subsequent decision on transfer of shares to the share fund, which was rendered after the Ministry of Economy instructed the privatization agency in accordance with Articles 46 and 47 of the Law on State Administration?
No, I'm not aware that such decision exists which established this particular fact.
Did you review the court decisions filed into the record of this arbitration to verify your response?
Yes, I did review them because it was on this particular file, because that was important for my assessment. I haven't found a single decision where this fact has been established.
Thank you, Madam President. We do not have any further questions.
Thank you. Can I turn to respondent, Mr. Jerish?
Thank you, Madam President. Good morning, Mr. Milosevic.
Good morning.
My name is Vladimir Đerić, and I'm counsel for respondent. You will now receive a bundle of documents in paper that can be turned by my colleague. You will also see the documents on the screen, so you may choose which ones you will consult. Now I will ask you a few questions. If you have any problems in following the documents, you just let us know and we will slow down and or return to the documents.
Okay.
Now, Mr. Milosevic, from paragraph 3 of your first expert report, I understand that you are now head of litigation in Živković Samardžić law firm in Belgrade.
Yes, I am.
How many people are in the litigation department which you had?
At this moment, there is, I have to count it, there is 6 attorneys and there is, I think, 5 trainees.
Thank you. Before entering private practice, you were a judge in district court until 2010, correct?
Yes.
That's in Serbian Viši sud.
No, that is the district court was had a competence of 2 type of courts today. This is Viši and Apelacioni, so that was just a single one, which name was district court.
Okay. Mr. Milosevic, what did you do as a judge in district courts? What types of cases?
All civil law cases under general jurisdiction.
Okay. Now, at your time, did the district court deal with corporate law, and especially privatization?
No, it did not directly,
Okay, so
but indirectly, yes.
am I right to conclude that your experience as a judge does not include cases dealing with privatization?
Not directly, but indirectly it does.
Can you just explain what you mean by indirectly?
Sorry?
Can you please explain what you mean by indirectly?
Yes. Under the factual circumstances in some cases, it was often that the issues which are related to the privatization agreements did arise. So I haven't directly decided, was not deciding directly upon privatization agreements and their fate, but I had indirectly those issues that should be ruled on.
Thank you.
Okay, let's try to specify then the meaning of indirectly. Did you deal as a judge with termination or with the cases involving termination of a privatization agreement by the agency?
No, I did not.
Thank you. Have you published anything on privatization in a law review?
No, I did not.
Have you published anything on administrative law in a law review?
No, I did not.
Thank you. If you can turn to paragraph, to your third report, paragraph 33. In the second sentence of the paragraph, you say, quote, I have already demonstrated above that Serbian law recognizes the existence of beneficial ownership. Is that correct?
Yes, it is correct.
Okay. Now, if I ask you to turn to Exhibit C 867, which is the law on the prevention of money laundering, okay, Serbian law on the prevention of money laundering, and if you could take a look at Article 3, Paragraph 1, Subparagraph 4. This is also a provision that you quote at paragraph 24 of your third report, for the record. Now, if you can read that.
Yeah, I can read. Yes.
Okay.
Yes.
Can you read, please?
Yeah, I can. Person under foreign law means a legal arrangement which does not exist in domestic legislation established to manage and dispose of property, e.g. a trust, a stalt, fiduciary, fideicomiss, etc.
Thank you. Now, does this provision state that trust does not exist in domestic, that is in Serbian legislation?
I don't understand. What are you asking me? You want me to interpret the meaning of this, or to just literally answer? Can you just rephrase the question in order to understand you better?
Well, you read that provision.
Yes, I did.
And I ask you a simple question, whether it says that trust does not exist in domestic legislation. And I believe it does say exactly that.
So you want me to interpret this?
No, I want you to confirm
Well,
whether
actually,
the
I
says
don't
that.
think it says that that this does not exist in domestic. It just is aimed to extend the meaning to foreign law, and it is just defining what does it mean here. But it doesn't say that it does not exist under the domestic law.
Okay, let's read the provision together.
Yeah, what do you want to?
Well, just give me a sec.
Okay.
So it begins with saying person under foreign law means, right?
Yes.
And then it says means a legal arrangement, right? And then it describes this legal arrangement and says, which does not exist in domestic legislation. Is
Okay.
that correct?
Okay.
And then it further describes it, and this is not important at the moment, established to manage and dispose of property. And then it gives example of this legal arrangement which does not exist in domestic legislation. And the first example it gives is a trust. Is that correct?
Yeah, it says that, yes.
Thank you. Now, are you aware of any decision rendered by a Serbian court recognizing that shares of a joint stock company registered in the name of one natural person are actually property belonging to another person or to another entity?
No, I am not.
Thank you. Now, can we please go to paragraph 205 of your second report? And this is part dealing with the SEMBI agreement.
Just a second, please.
Yes, please. Please read it. Paragraph 205.
Okay.
Ready?
Yeah, I am.
Okay. Now, if I may rephrase what you said, and you will tell me whether I'm correct in rephrasing it. You basically say that SEMBI agreement is not an assignment agreement to which consent of the privatization agency would have been necessary.
Yes, that is correct.
Then, thank you. And then you say that a further agreement would be necessary in order to transfer the privatization agreement from Mr. Obradović to SEMBI. Is that correct?
Yes, that is correct.
Okay. On this basis, is it correct to conclude that the privatization agency has nothing to do with the SEMBI agreement, that it is for it what we would say in Serbia, or in Latin, res inter alios acta?
Well, I would not say that. This implies what I said, that is, implies that what it is said here, that this is related to my conclusion that it does not have effects of the assignment agreement, and that is all.
Okay, but does the SEMBI agreement entails any rights or obligations of the privatization agency?
Well, actually, from this agreement stems the contractual relationship between the contractual parties. As one of these parties in the relationship with the privatization agency, as I have explained in my expert report, it is a duty to the privatization agency not to interfere or not to cause any damages to this relationship. In that regards, it has significance for the agency under condition that the agency has been acknowledged of existence of such relationship.
Has the agency been acknowledged of the existence of the SEMBI agreement? Do you know?
Madam President, yeah.
Sorry. Well, I have been advised that it has been acknowledged I don't know whether it has been acknowledged on this particular contract agreement, but I am advised that it has been acknowledged that there was relationship between the parties to this agreement.
Okay, let me just rephrase the previous question. Is the Serbia agreement an agreement as any other agreement between third parties or the privatization agency?
Well, for the privatization agency, it is.
Okay. Thank you. Okay, let's move on a little bit on the privatization now.
Okay.
Now, in paragraph 28 of your first report, you state, quote, "The primary goal of privatization has been to create better conditions for the development of Serbian economy, social security, and economic well-being." Is that correct?
Yes, that is correct.
Okay. And then in the next paragraph of the same report, you refer to 2001 law on privatization, and you say that it explicitly stipulated that one of the main principles of privatization is creation of conditions for economic development and social stability. Is that correct?
Yes, that is correct.
Okay. Now, would you agree that privatization agreements by which socially owned companies were sold were one of the main instruments of privatization, by which privatization was conducted?
Well, I cannot completely agree with that. The privatization agreements was just the one aspect of the privatization, but the fact that the proceeds from privatization were aimed to the state budget and then used in accordance to National Investment Plan and all other strategies of the government, it was as much important for privatization, even much more important for privatization than sole privatization agreement. But yes, the privatization agreement was also one of the crucial elements in that policy.
Okay, thank you. Now, having in mind the purposes of the privatization that we mentioned, that we just mentioned, could we say that the purpose of privatization agreements was not solely or exclusively and simply to get the money from selling the socially owned companies? Would you agree?
Yes, I would agree with that, yes.
Okay, well, we will return to that. Now, moving on to the reasons for termination of the privatization agreement, and if you kindly could look at the privatization agreement CE 17. Or actually, better to look at, unfortunately, we don't have two screens, but it's better to look at the moment in Article 41A. But we are going to deal with these two questions now. Mr. Milosevic.
Sorry, if you have Article 41 in written, then it will be sufficient. Okay, it's okay. Just find Article 41A or...
It is a rather general question.
Either one or seven.
article.
If you can provide me with one in written form and the other can be on screen.
Right.
I would suggest that, maybe that would be the easiest.
Okay, so we have Article 41 on the screen and 41A on the screen, and my question will, first question will relate to that.
Okay.
It's a very simple question. Mr. Milosevic, do you think that the agency could terminate the privatization agreement just on the basis of Article 41A of the law on privatization?
Not in all cases, because there are provisions which should be connected to the agreement itself. If you are asking about reasons for termination.
Could you please point to that, to such provision?
Yes, I will. It is the 41A, paragraph 1, item 3.
Okay.
And I will explain why.
But would you agree that this particular paragraph and others as well refer to the privatization agreement and its provisions and the violation of its provisions, but do not refer to a particular provision of the privatization agreement dealing with privatization?
I don't just, if
Okay,
you can
put it this
rephrase.
way. Let's say that there is no Article 7 in the privatization agreement, article
Okay.
which defines the grounds for termination. Would it be possible to terminate the privatization agreement simply on the basis of Article 41A?
Okay, it's a hypothetical situation, and hypothetically, if there would not be no Article 7, which provides grounds for termination, in particular privatization agreement, then just I would like to see Article 534 before I finish my answer, if possible.
Sure.
Because you are asking me if
It
it
will be
would be
projected on the
possible to terminate for that. May I ask for, yeah. Yeah. I don't think it would be possible to terminate privatization agreements even if there would be no Article 7 for this reason. That's Article 534.
Would you care to explain?
Sorry.
Could you explain, please?
Yes, I can explain. And maybe it's easier to, I will maybe need one legal authority on this. Just give me a second to find it. Is it possible to see the CE 714? This is the commentary of the Professor Wiesner to the law on obligations.
I'm sorry, we will go to Professor Wiesner later. My question was simple. Is it possible to terminate the privatization agreement simply on the basis of law? Let's suppose there is no Article 7.
I will provide you short answer, then we can discuss it further when we come to Professor Wiesner. I don't think so, because this provision is aimed to support other provisions. It cannot stand on its own. It doesn't have any purpose on its own. It only supports other provisions.
Which provision are you referring to?
Article 534, that is the provision that we are talking about.
When you say this provision supports other provisions, do you mean this provision is Article 7 or 41A?
No, I mean, yeah, I will try to clarify this. I'm trying to answer to Mr. Jerry's hypothetical question, which provides if it would be possible to terminate the privatization agreement for the breach of the Article 534 in connection with the law on privatization, Article 41A, paragraph 1, item 3, if the Article 7 in the privatization agreement does not exist. My answer was no, it would not be possible to terminate the agreement even if Article 7 hypothetically do not exist. The reason why it could not be possible to terminate just for this provision is that this provision supports other provisions. The point is, this is accessory obligation and the other provisions are main obligations. So this provision could be the ground for termination only if it happens before all other main obligations are fulfilled and before the term of the main obligations, negative obligations, expires. Okay. But to be terminated after fulfillment of all other obligations and after the term of negative obligations, main obligation expires, by my opinion, it would not be possible because this is the accessory obligation which does not have purpose on its own, if that answers your question. And I can provide more detailed explanation when we come to Professor Wisner.
Okay, we will come to Professor Wisner in a second. Now, just one quick question. Are you actually saying that the way the parties draft a contract could affect the way Article 41A of the law on privatization is implementing or binding or operates? So in that way, parties could sometimes put something in a contract that would modify Article 41A, and sometimes they would not?
No, I didn't say that. I didn't say that way. Yes, the parties can provide provision which could have impact on implementation of Article 41A. If you
let's
want,
look at Article 41A, and then okay, we will move to Professor Wisner, as I have promised.
Okay.
The Article 41A says that, quote, the agreement on sale of the capital or property shall be deemed terminated due to non-fulfillment if the buyer, even within an additional granted term for fulfillment, and then the provision that you mentioned, if the buyer disposes of the property of the subject to privatization contrary to provisions of the agreement.
Yes, it says so.
Are you saying to me that the parties could actually say that this does not apply?
No, and not at all. I didn't say that. What is the proper meaning of the item 3? The important words are contrary to provisions of the agreement. The legislator provided the parties to give specific meaning to this provision, which means they cannot replace, they cannot avoid this provision, but they can stipulate specific meaning to this provision, which they did in particular privatization agreements. We have Article 533, which treats disposal of the property in some limits which are provided. And we have Article 534, which is not under Article 7, and that is the will of the parties, which is where the legislator provided them to do so. So they are not excluding this provision, they are just giving specific meaning to this provision.
Okay. Mr. Milosevic, turning back to Article 534 of the privatization agreement.
Okay.
Does this provision, if you can take a look, does this provision regulate the disposal of the property by the buyer?
Just if I may, Article 41A at the same time. I need a cross-reference. Article 41A.
I'm asking you about the contracts. Now I'm not asking you about the law.
Okay.
So if you look at the contract and tell me whether Article 534 regulates disposal of the property.
It regulates prohibition of the buyer to cumulatively to perform two things, and that is to encumber the assets with a pledge in order to gain loan for the third parties, let's say, that way. If that answers your question.
Yeah. Well, but that is actually disposal of the property, which is regulated in that provision, right?
Can you be more specific on the question?
I don't think so. I think that I can use the Serbian word from the article, but I think that my question was specific enough, whether this is disposal of the property, which is regulated in Article 534.
Well, if you're asking me whether the burdening the asset is could be considered by the Serbian law as disposition, yeah, it could be considered as disposition.
Thank you.
But as I have said, if you go back to the paragraph 3, it doesn't forbid all disposition with the property. It established ground for termination only for dispositions which are contrary to the agreement.
Exactly.
And if we look into the Article 7, where the parties stipulate which are the main obligations which are sanctioned by termination, we will not find Article 534. We will find Article 533, but we will not find Article 534. So not any disposition is sanctioned with termination.
Okay, thank you. Okay. Now, we have heard in the opening statement and today a reference to Professor Wisner, and I'm going to move on to that today. Now, according to Claimants Council, and you have part of the transcript in your bundle, in their opening, Serbian law provides that a contract may be terminated only for a violation of an essential obligation and only if such violation is not minor. That is page 43.
You are talking about opening statements.
Sorry, just wanted to give the reference. That's the transcript.
Yeah, I understand what you mean. You're talking about opening statement of the claimants.
Exactly.
Okay, I understand what you are talking. Yeah.
Okay. Do you share this position?
Yes, I share. I share it.
Okay. And if you take a look at their the slides that they presented at the opening, that is slide 109. They say that the concept of essential obligations exists in Serbian law. And there is a reference to Professor Wisner, right? You see that
Yes.
on the bottom of the...
Yes, yes.
Uh,
Yes, I see.
okay. Now, this is also your position.
Yeah, this is also my position.
Thank
I
you.
have wrote it in my...
Now, can you tell us the year when this commentary of Professor Wisner was published?
I don't know exact year,
Says-
but it
sorry,
is...
sorry,
what?
it says on the bottom of the screen.
Yeah, it says on the... Yeah.
Could you say that for the record, please? Does it say 1978?
Yeah, it says 1978.
Okay. So this is about 40 plus years, right?
Yes, but actually the law hasn't changed substantially from 1978. It's
Okay.
the same law as it was then, and Professor Wisner is still very respected authority in Serbian judicature.
So the law was also, the law on obligation was also adopted in 1978.
Yes, it was.
Okay. So that means that the Professor Wisner's commentary was adopted the same year the law was adopted, was published the same year the law was adopted. Is that correct?
Well, yeah, it is correct. And it is quite logical because the Professor Wisner was participating in a group drafting the law, and he is the one who knows the best what was the real, what is the ratio legis and what is the real interpretation of some provisions. So yes, I would refer to him.
But you would agree that this commentary, which was adopted on the same year, which was published the same year the law was adopted, does not and could not take into account the 40 years practice of implementation of the law on obligations?
Well, I do not know of any other practice. If you know that there is any practice which is contrary to this, I would like to share that.
My point is that, would you agree that there is more recent literature on the law of obligation which is not 40 years old?
Well, I don't know really. On this particular issue, no, I don't know.
Thank you. Now, back to the substance, what Professor Wisner says here.
Mm-hmm.
Would you here first agree that Professor Wisner writes about Article 131 of the law on obligation and talks then about what is an insignificant part of obligation and the termination in that case if only an insignificant part of the obligation was violated? Is that correct?
Yes, that is correct.
Okay.
And it would be good to, if possible, to see the full, because in my expert report, I have cited only one part, small part of his opinion, but there is more which clarifies this relation of the term insignificant part with situation when this is related to termination because of a breach of one out of more obligations. So I can explain that if you want and lead you to the conclusion why did I use the word essential obligation and not any other word. But I propose to see what Professor Wisner says on that issue.
Well, my question is exactly in your report, and that is your second report at paragraph 95. You speak of an essential obligation, of essential obligations, and you refer to Article 534. You say it's not an essential obligation. But
Yes.
you don't give us any reference to the concept of essential obligations.
Okay, if you want me, I can provide it here at this spot, if you need clarification on that.
Well, We can,
Just say so and I will provide it.
we cannot introduce now new exhibits.
No, it's no new exhibit. It's
Can you
based
then
on the...
then you refer me to the exhibit?
Yes, I can clarify it,
Please
how
do.
to read it. If you want me to answer your question.
No, my
then-
question is very simple. In paragraph 95, your opinion, you speak of essential obligations, and then you don't refer to any authority. My question is, where do you find authority for essential obligations?
Well, if you want me to answer your question properly, then I suggest to open the Professor Wisner's commentary. I saw it on the screen
Okay,
previous, and then I will explain
please do.
as brief as possible. If you can scroll a bit down, I will find, just to find the part which is more down. Yeah, that. There is a sentence which says any dispute on the matter, and the paragraph below that one. If that could be marked just for the tribunal to see that. Yeah, thank you very much. Thank you very much. And now I will explain. So the Article 131 of the Law on Obligation provides that the obligation, the agreement cannot be terminated due to unfulfillment on insignificant part of obligation. And that is what Mr. Jejic is asking me, how it comes to be insignificant breach. The Professor Wisner recognized the problem because he recognized two situations, that insignificant part could be related only to divisible obligation, but there are also obligations which are not divisible, and there are situations when there are more than one contractual obligation. So he recognized that problem, and this is where he explains how to deal with it. And he says, it must be determined whether partial breach relates to a principal or ancillary obligation, and then whether performance of the obligation is divisible or undivisible. As a rule, termination of a contract is possible and permissible only in case of partial failure to fill the principal obligation, and not in respect of a subordinate obligation. Similarly, termination of contract is possible in the case of failure to fill of an indivisible obligation, so it is possible, whereas the legal rules, that's the other part is something else which is not related to this. So he concludes that if there is more than one obligation and only one obligation is not fulfilled, the first thing that should be determined is whether that obligation is principal or ancillary or accessory obligation.
Okay.
However, I have not finished. If you allow me,
I do.
this is the part where I want to link it with essential obligation. So this leads us to the conclusion that the agreement cannot be terminated if only minor obligation has been breached, but not the principal one. But as we know that by the will of the parties, sometimes the minor obligation can be also essential due to in the meaning of the Article 26 of the Law on Obligation, which provides agreement is concluded when the parties achieve consent on essential elements, period. So if the parties agree that the minor obligation is an essential element of the contract, then the agreement can be terminated also for breach of the minor obligation. This rule could not be applied in that situation. I will give you example. In a banking loan, it is usual to stipulate that the debtor or the client is due to provide security for the loan. This is accessory obligation. But it is also usual that the bank provides that this provision is sanctioned by termination, by putting it in special provision which says if the buyer doesn't provide security, then the bank could terminate the agreement. By this minor obligation, which is accessory obligation, is becoming an essential obligation. And that is why I have used the term essential obligation. It seemed to me that is, more honest to use this word than to use word principal obligation. So that is it. For the same reasons as we have two situations, which one extends above the divisible obligation, I did not use the term insignificant part, but I used the term insignificant breach.
Mr. Milosevic, thank you for this explanation. I just have to say that it's not in your report, but it's very useful. My question to you is whether, so you are saying that a principal obligation is not the same as an essential obligation. There is a difference.
Yes, there is a difference between principal and
essential. But Professor Wisner here is talking about principal or about essential obligations?
I have just explained why did I use the term essential. You can also translate it as principal. It will have the same meaning. Just essential provides, let's say, extended scope because it covers a situation when the minor obligation can also be essential.
If there is a difference in English between principal and essential, is there a difference in Serbian? What are the Serbian words that you would use? This is Serbian law.
Mr. Jeric, I don't think, yes, I can say principal is glavna and essential is bitna in Serbian.
Okay.
So I don't think you have understand me on my answer. So you can also translate this everywhere where I mentioned essential obligation, you can translate it as principal obligation. It will be okay with me.
Can I just ask a clarification? If I try to summarize what you're saying, you say you can terminate for breach of a principal obligation.
Yes,
and
exactly.
You can also terminate for breach of an ancillary essential obligation.
Yes, that is correct. Can be terminated for breach of ancillary obligation if the parties provide consent that this will be an essential element of the contract. Yes.
Mr. Milosevic, I understand your explanation, but I would like to ask you, do you have any other authority in Serbian law that supports this obligation, this theory of yours? Because we have seen that Professor Wisner is not using the word essential or, as you said, in Serbian, remind me,
Rivna.
bitna.
No, I do not have it.
Thank you. Okay.
Before you leave this, can we just have the page of C714?
Yes.
Yes, thank you.
All right. Can we now discuss the obligations under privatization agreement in the light of Serbian court practice, see what they have to say, and if we can turn to RE 62, page 5.
Do you have Serbian version here, maybe. It would be easier for me to read fast.
Okay, at page 5, you can see the quote.
I think you need to identify what it is.
Sorry?
You need to identify what it is for the transcript.
I'm sorry, I said, yeah, RE 62.
Yes,
page
but it's a
5. Yes,
decision
sorry,
of this and this court of this and this
This is
year.
the, sorry, this is the judgment of the Supreme Court of Cassation of Serbia from 2013, Exhibit RE 62, page 5.
Okay.
And it says, if you can bear with me, the goal of privatization defined by Article 2, paragraph 1, item of the law on privatization can be achieved only through full realization of all contractual obligations. Failure to perform any of the contractual obligations obstructs the very purpose of privatization. You see that?
Yes, I see that.
Okay. And a little bit further. No. Let's stop here for a second. Let's suppose that we accept your theory about essential obligations.
If you would allow me just to.
Oh yeah, please do.
Just pay just a quick look. Okay, I cannot see just from which period was the agreement on the privatization agreement. What was the date of the privatization agreement? No. Yeah, it was even before 2003. Yeah, the privatization agreement was from 8th April 2003. Okay.
Okay, but you will agree that this is a kind of general pronouncement by the Supreme Court of Cassation, as Supreme Courts of Cassation usually do, and it says that the goal of privatization can be achieved only through full realization of all contractual obligations. And would you say, if we accept your theory of essential obligations, and how they are defined, would you say that this means that actually all contractual obligations under the privatization agreement are essential obligations?
Well, I don't think this is a good example for two reasons. First, it does not fit in, it doesn't bear the same facts of the case as in this case, because as I can see on the page 6 in Serbian version, this was the termination due to the failure of the buyer to provide additional investments, which is the main obligation. This is not at all the same obligation as the obligation from 534. That's one thing. The other thing, and I have checked it, it is dealing with the privatization agreement, which has been concluded in 203. And just for the purpose of clarification, maybe for the tribunal, I would like to be more clear on this. There are 3 periods which are relevant for the case law, and maybe to help even more, that is very well explained in the Mr. Slobodan Spasic article, where he just discussed on this. First period is from 2001 to 2003. In this period, which is related to this particular contract here, the law on privatization did not have any provision on which regulates the termination of the privatization contract. So the case law should have to rely on the loan obligations and on particular provisions of the agreement. So in that period, the courts tend to interpret all the agreements that all of the provisions are equally important. But it is completely different situation in this, and this case law is not applicable to this case.
Okay, let's find some other case law. Let's look at RE 166. That is the decision of the judgment of the Supreme Court of Serbia. That is from 2006. And it now deals with yet another obligation of the buyer. If you take a look at page 1, first paragraph, last paragraph.
I will just read this, and if you can allow me just to read the full.
The full decision.
Mm-hmm.
Okay.
So, okay, let's try to speed it up. What did you say? What was the period here when the agreement has been concluded?
Well, let me just ask a question first.
Okay.
Yeah.
I will reply. Everything that I
Sorry,
everything that I said for the previous example is applicable to this one. At 2004, they were already terminating the agreement, so it is certain that it was before 2003. And if you look at the beginning of this, if you can scroll up a bit, you can scroll up just a bit up. Yeah. Thank you. Thank you. Second sentence says, during the first instance proceeding, it was established that the defendant did not fully perform all assumed obligations. So we have a situation where the buyer was defended and the agency was the plaintiff. That did not happen after 2005, because before 2005, the agency had to initiate litigation in order to terminate the agreement and to effectuate termination by transferring of shares. After 2005, it was acted as a holder of public power who was entitled to terminate the agreement and to transfer the shares by its own unilateral decision.
Okay, but if you look at these quotes, and I would actually didn't even ask you a question still, but it says here, all contractual obligations from the contract on the sale of the socially owned capital are equally important for achieving its goals.
This is not what is marked, sorry. Okay.
So, would you agree that this statement is mentioning the goals of privatization? Right? And it says that all contractual obligations are important for the goal of privatization? Is that correct, what the court is saying?
Yes, but this particular statement is not in any way different comparing to my conclusion. If you look into the starting of the paragraph, if you want to answer, if you want me to answer, let me to answer. If you allow me, I will clarify. If you do not want me to answer, that's okay.
My question was, does the court say that all contractual obligations from the contract are equally important for achievement of the goal of privatization?
Yes, but it provides the breach of the major obligation, which can be seen at the beginning of paragraph. It was obligation to pay the contractually defined amount of salaries to employees. Of course, it is major obligation.
Yes, but
It's not,
does the court say, it says what you are saying in the next sentence, but in this sentence, does it say that all contractual obligations are important for the goal of privatization?
well, this is,
It's a simple question, yes or no?
well, if you want me to read what the court says, yes. But if you want me to extend this
you
to the
can
all
extend it
cases,
already,
I
Mr.
cannot
Milošević.
extend it.
Now, can we go back to RE 62? Okay. Does this, the highlighted part, also mention the goal of privatization that can be achieved only through full realization of all contracting obligations?
If you are asking me to read, I can say yes. If you're asking me to give you my opinion, I have already provided opinion
Yes,
that
you did.
either of these decisions are not applicable to this particular case. And I provided the reasons why.
Okay. Now, tell me the goal of privatization. We have discussed that at the very beginning. And you confirmed what the law says, that the goal of privatization is the creation of conditions for economic development and social stability. Is that correct?
Yes, that is correct.
Okay. And then I ask you whether the goal or the purpose of privatization agreements, considering this goal, was not solely and simply to get the money from the privatization,
Yes,
but to
and
achieve this goal.
yes, and I have already answered you, affirmatively. Yes, that was not the only goal to
And
to
can you
to
now
get the
tell
money.
me, despite all these changes in law, has the goal of privatization, as defined initially in the law on privatization that you referred to, that is Article 2, Paragraph 1, already in 2001, has this goal changed in any way, and has this provision been amended in any way?
Basically, it hasn't changed. It remained the same,
Thank you.
the main purpose.
Okay, now moving on to the second limb or second element for termination according to claimants and yourself, and that is that the obligation must not be insignificant, in reference to Article 131 of the Law on Obligations.
Okay.
Now, can we have Professor Wisner's excerpt on the screen in the part that was quoted by the claimants and Mr. Milošević?
So this is C714, right? Just
Yes,
for the
I'm
record.
just going to confirm that, sorry. That is... Yes, it is 714. And I would now like to discuss the precise quote that you use and that claimants use. And it says that if it turns out that a debtor has not fulfilled only an insignificant part of its obligation, and this insignificance does not factually endanger the creditor's interests, regarding the remaining part of already fulfilled contractual obligation, and accordingly does not endanger the achievement of the main goal, the main purpose of the agreement. See that?
Yeah, I see.
That's the end of quote. Now, does Professor Wisner actually say that there are two elements when applying, or two conditions or requirements when applying Article 131? First, that there must be an insignificant part of the obligation, right? And then says, and he uses "and," this insignificance does not factually endanger the creditor's interest, etc., etc. So do you read that as two requirements?
They are connected by the word accordingly, but I would agree with that interpretation, yes.
Okay. Now, so Professor Wisner actually qualifies what the plain text of Article 131 of the loan obligations provides. Would you agree?
In this paragraph.
You agree?
Yeah, I could agree with that.
So according to Professor Wisner, you can terminate a contract even for an insignificant breach if such breach endanger the purpose of the contract, affects the purpose of the contract.
Well, actually, it is not what Professor Wisner says here. And that is important to provide this second paragraph also, which is stipulated here. He also says that explicitly that just a second. Yeah, the first paragraph, which is not cited in my, but I have already explained, just not to repeat all.
Can you repeat?
I'm referring you to the first marked paragraph, second sentence, where he says, as a rule, termination of contract is possible and permissible only in case of partial failure to fulfill the principal obligations. So he is very explicit in that.
Yeah,
and what are you asking me is whether it is possible to terminate for the minor obligation if that would endanger the purpose of the contract. That is your question.
Exactly.
And I have already explained, yes, it is possible. But if the parties, in the meaning of the Article 26 of the law obligation, already provided that particular minor obligation would be the essential part of the agreement. The Article 534 was not provided as essential part of the agreement.
Let's stay with Professor Wisner.
Okay.
And if Professor Wisner is saying that that insignificance does not factually endanger the credit, this insignificance has to factually endanger the creditor's interest and the achievement of the main purpose of the agreement. Does he mean actually the same thing as you? That there must be an agreed purpose which tells us that some obligations are essential, as you say.
Well, this is a theory statement. So he had to make broader margins here. So yes, I would agree with him, but I have tried to connect these theory statements to the particular case and to implement them, explaining you why I have qualified these as essential or non-essential obligations.
My question is, again, going back to my first question,
Okay.
does that mean that that even or despite the Article 131, or that Article 131 of the Law of the Obligations has to be interpreted, that you can terminate a contract, even in the case of insignificant breach, if such insignificant breach is related to the purpose, to the obligation that is connected to the purpose of the contract, or the breach is related to the purpose of the contract?
Well, and I explained you an example. I mean, if we look to his opinion, we have to look it as a whole, not only fragments. The first part is the part where he explicitly says that the agreement cannot be breached, can be terminated because of the breach only of principal obligations and not for minor obligations. And I have already explained the situation where it can be terminated also for minor obligations.
Actually,
I don't know what is.
No, I'm
what
asking
do
you what
want
you're
from-
actually saying in your report. We have one situation that is not relevant at this particular moment, and that is the breach of what Professor Wisner calls principal obligations. And then we have a situation of Article 131 of the Law on Obligations, which is the breach of insignificant obligations, right? There are two different situations. Would you agree?
Yeah, I could
Okay.
agree. Yeah.
So when he comments Article 131, and I thought you take the same position, Professor Wisner says, and I quote, that if it turns out, quote, if it turns out that the debtor has not fulfilled only an insignificant part of its obligation, and this insignificance does not factually endanger the creditor's interests, etc., including the main purpose of the agreement, then such agreement cannot be terminated. So, I'm just turning it around. So if it endangers the main purpose of the agreement, insignificant breach can also be a reason for termination.
Well, I think this is too far from the issue of principal and ancillary obligations. By definition, minor obligations, accessory obligations, cannot endanger the agreement unless the party stipulates it that way. But in that situation, it is essential part of the contract, and it is completely different situation. I mean, we can theoretically and hypothetically run this over and over, but the result will be the same.
Sure. Well, let me now turn to your report, second report, paragraph 96, where you say in the second sentence, the highly regarded Professor Wisner explains in his commentary, quote, that this is quote from you, that the assessment whether the breach of an obligation was only minor must not only be quantitative, but also qualitative.
Yes.
Okay.
That's correct.
So the assessment whether a breach was minor can also be qualitative. Is that what you're saying?
Yes, that is
Okay.
correct.
And how do we assess whether a breach was qualitative? Do we do that by looking at the purpose of the
Yes,
contract?
that's correct. I agree with that.
So if the breach, minor breach, is related to the purpose of the contract, then you can terminate even for the minor breach.
I didn't say that, nor the Professor Wisner said that.
Okay. Let's stop here. Let's just go back to the purpose of the privatization and privatization contracts. Okay. This is the third time, so I guess we can just quickly recall that you agreed with me that the purpose of the privatization and privatization contracts is achievement of economic and social stability and not only the payment of the purchase price.
Yes,
Now,
I agree with that.
If we agree with that, and if we assume for a moment, and we don't agree with that, that Article 534 could be a breach of Article 534 could be an insignificant breach.
Sorry, I don't know. Yeah, okay.
Would
finish
you
your question.
say that Article 534 is connected to the purpose of the privatization? The
Just
Article
if you-
534 of the privatization agreement.
Sorry, if you can just rephrase the question, I'm not sure that I
Is the
understood you
purpose
properly.
of Article 534 of the privatization agreement related to the overall purpose of the privatization?
Well, as it is accessory obligation, I would not go that far. Its purpose is to support other provisions of the privatization agreement, which provides the purpose of the privatization.
Well, obviously, I know that you're saying it's an accessory, and that's why I'm asking you on the basis of hypothesis that it is a minor breach, and it is a breach of Article 534 is a breach of an accessory obligation. But under that assumption, and you agreed that we have to take a qualitative analysis, as you say in your report, and look at the purpose of the agreement and whether a minor obligation is connected to the purpose of the agreement. So my question to you is whether Article 534 is connected to the purpose of the privatization agreement.
I think the expert gave the
Expert
answer.
has this-
I understood him to say, no, it is not related to the purpose of the privatization, but it supports other provisions that are related to the purpose.
Yes.
And you, of course, correct me if I misunderstand.
Yes, yes.
Okay.
Madam President, you understand me very well.
Okay, let's me rephrase that. How does the Article 534 works, or what it protects? Does it protect the property of the privatization privatized company?
Well, actually, it does not protect the, I would not say that it protects the property of privatized company, but it protects that the, and I could say so, that the buyer would not, for example, strip the assets of the company before he fulfills all other main obligations and before the term of negative obligations are expired.
So you said it prevents the buyer from stripping the assets of the company.
Yes, I said
would
that.
understand that as protecting the assets of the company or the property of the company.
Yes, it is protecting the assets of the company, I would say so, yes.
Okay. And
But so just with one difference, it does not protect the assets of the company, it protects the other provisions which protect the assets. I mean, the main obligations. It does not directly protect the assets of the company.
okay. And a healthy privatized company, is it important for the economic stability of the country?
Yes, of course.
Workers that are paid their salaries
Yes,
from
it
the
is
assets of the
important.
company, that's important, right?
Yeah, it is important, of course.
So safeguarding the assets of the company is important for the goal of privatization. Is that correct?
Yeah, that is correct.
Madam President, maybe we could make a break here, if you wish, or we can continue.
Or if you wish.
Probably everyone wishes.
Yes, Do you have an indication of how much longer you will need? That is
15
after
minutes
the break.
break,
You
but
15 minutes break, but half
I would say not as much as we already did, but let's say, yeah, 1
About
hour.
an hour?
1 hour.
Good, fine. Let's take a 15-minute break now. And Mr. Milosevic, while you're on the stand testifying during breaks, please do not speak to anyone.
I will not, Madam President. I understand that. Thank you.
Mr. Milosevic, are we ready to continue?
Yes, Madam President, I am.
Good.
I'm ready.
Mr. Jerish, please.
Thank you, Madam President. Well, good morning again, Mr. Milosevic. Now, let's pick up on some of the things that we have already discussed. Article 534, for which you said is an accessory and insignificant obligation under the privatization contract, correct?
Yes, correct.
Okay, let's suppose that the buyer mortgages 100% of the company's property for the benefit of third persons.
Okay.
That would be a violation of Article 534, correct?
Yes, but that would be insignificant.
Would it be still insignificant? That was my question.
Yeah,
Although
that depends. That depends on the performance of all other obligations. Because if the buyer perform all other obligations, then it would not be significant.
Okay.
And before the last obligation, which would be payment of the purchase price, the last installment of the purchase price, would payment of the last installment of the purchase price, it would lose its purpose.
Okay, we'll come back to that as well. But would you agree that mortgaging 100% of the company's property in violation of Article 534 in principle would not be an insignificant or minor violation of the privatization contract?
Well, that is a hypothetical situation, which is very far from the situation which happened here.
Yes, it is hypothetical, obviously, but I'm just asking you, I can rephrase the question. Is there any, is this, is there a possibility that a violation of Article 534 is not insignificant?
Well, it would be not enough. This would not be, I would have to assess all the facts. This is all speculation. I know. Theoretically, yes. Theoretically, yes, it could happen. But I know it's just hypothetical answer to hypothetical question. In order to provide proper answer, I would have to assess all the facts in order to give you a proper answer whether it is or it is not significant breach.
Sure. Okay, let's have another hypothetical, which I think will help us. I mean, hypotheticals are here to help us with understanding what Serbian law is. Now, would you agree that investment obligation is one of the, you say, essential obligations under the privatization contract?
Yes, I would agree with that. Yes, it is.
And why is fulfillment of the investment obligation important for the privatized company? Is it important because it will improve its financial standing?
Well, this is more complex issue, but let's say it would be in the accordance with all goals of the privatization process.
Yeah, but can we be more specific? Why is, in your opinion, the buyer required to invest in a privatized company?
I did not assess that, but I have I have interpreted that provision as essential one, because
yeah,
it's
but
obvious.
What is the purpose of that provision in the contract?
The purpose is to provide some as other obligation, as continuity of a business, as providing the social program. It is aimed to improve economic stance of the privatization subject, yes. For
Thank
that part, I would agree, yes.
Okay, so now coming to the hypothetical. Let's say that the buyer has the obligation to invest in the subject of privatization for 5 years after concluding the contract. As he was fulfilling this obligation, not only 4 years has passed, so he has not completed this obligation. There are still certain parts of it, of this investment obligation that he has to fulfill, and he has to invest the remaining funds. Okay.
Okay.
Now, the buyer decided to pay the purchase price before it was due, and it paid it in 3rd or 4th year.
Okay.
Would you say that in that case, the buyer's obligation to complete the investment does no longer exist?
No, I would not say so, because there are two types of main obligations. The one are positive obligations, which are aimed to some performance, like payment of the purchase price in some timely manner. The other obligations are negative obligations, which are some prohibitions. And both of them have some time limits. So in this example that you have provided, as I understand, we have one main obligation, which is providing this investment in the time, in the term of 5 years, and the other one is payment of the purchase price. So the payment of the purchase price was committed before the investment term has been finished. And of course, the buyer is due to provide additional investment because the term of the agreement has not been finished. And the agreement is not consummated by the payment of the purchase price. But it is a completely different hypothetical situation than the situation that we have here.
Okay, and then once it's confirmed that the privatization agreement has been fulfilled, now moving on to another situation, can the buyer dispose of its investment and, for example, donate the equipment he invested?
If you mean all main obligations are fulfilled and all terms of the
Yes.
provided for the main obligations has expired,
Yes.
yes, it can. It's
Thank you.
private property and it can dispose it whatever it wants.
Okay. Now, moving back to slightly different, but still same area, slightly different issues. In your first report, for example, at paragraph 111 and following.
111, you said.
Yes. I think it's a general, it's not a specific text, but a general point that you make, that your opinion, in your opinion, termination of a privatization agreement is an administrative act. Is that correct?
No, what you just stated is not correct. Just if you, do you want me to read or you would read
Well,
it?
if you start from paragraph 111 and explain
Yeah,
why,
I will
why
read
it's
it.
not correct.
So I did not say that they are administrative acts. I said that they have characteristics of administrative acts.
What's the difference?
Well, the difference is that I am a Serbian lawyer and I cannot ignore the case law. The matter of fact, the prevailing case law does not consider neither notice of termination nor decision on transfer of capital as administrative acts. And I have also stated it in my expert reports. But my scope was not to determine if they are considered in Serbian jurisprudence as administrative act, but to determine whether they have characteristics of administrative acts. And there's a big difference.
Well, I have a couple of questions there. Why is it then important that you mentioned that?
Sorry, I didn't understand your question.
If the Serbian law and the highest courts in Serbia are on the position that termination, notice on termination and decision on transfer are not administrative acts, and we have case law to that effect, why is it important for you to say that they have characteristics of administrative acts? And this is a quote from you.
Well, that was the question I was answering upon. I'm not into why it is important. That was my task, to assess the legal issue and to provide answer, which I did.
Yeah. Well,
Madam President, sorry, can I make a point of clarification? What would be, good morning, Mr. Milosevic. What would be these characteristics of administrative acts?
Yes. In the following lines of the same, you will find it in the paragraph 120. That's the interpretation of the Supreme Court of Serbia, which says an act by which a state body or company or other organization in exercise of public authority decides on certain rights or obligation of a natural or legal person or other party in administrative matter. And below that line there is the citation of the Article 4 of the law on administrative disputes, which provides that administrative acts, I will just, maybe it would be easier, I will just mark the characteristic. It is individual legal act, that's the first, by which, second, competent authority, by direct application of regulation, decides on particular right or obligation of natural or legal person or other party in administrative matter. Those are characteristics of administrative acts.
Thank you.
Thank you. Mr. Milosevic, you are an expert on Serbian law, and you are here to tell us, I guess, what Serbian law is. And you have just said that Serbian law does not recognize termination of the privatization agreement as an administrative act. Is that correct?
I did not say that. I said that Serbian case law does not recognize it as administrative acts. And that is the fact I didn't ignore. I stated it even in my expert report.
Okay, so this is only your opinion, de lege ferenda, as I would say.
It is my opinion that there are elements that this could be assessed and characterized as administrative acts. The matter of fact, the case law doesn't fit to that characterization, prevailing case law, Serbian case law.
But no one shares that opinion with you, that we know of.
Well, can you define me, no one, who that is?
Legal authorities, commentators, court practice, scholars on Serbian law.
Well, let me say it this way. I don't know on any case until now that Ministry of Economy directly involved in privatization process by issuing instruction on the grounds of Article 46 and Article 47 of the Law on State Administration,
Did you,
instructing the agency what to do with the privatization agreement and implying that it should be terminated.
could you tell us where in your reports you provide this position or statement that you have just said?
Where in reports?
Yeah.
I have provided it. I cannot at this moment tell you, but if you want to wait, I will find it.
Well,
If that is important, just I need some time to find it.
well, we will find it or not find it by ourselves. Thank you.
Okay.
Now, let's go to another point, and that is that you mention, for example, in your first report, paragraphs 105 and 109, that termination of the privatization agreement involves an irrebuttable presumption that the buyer against whom the agreement was terminated is a, quote, dishonest party. And then that it cannot, or the buyer cannot claim restitution of purchase price upon termination.
Yes.
Could you please tell us or explain to us, what do you understand as, what is your understanding of the concept of rebuttable presumption under Serbian law?
I will. In order to be more clear, I would kindly ask if we can provide on screen the Article 41A, paragraph 3, if possible. Paragraph 3. So 41A, paragraph 2001 law, 2005 version. Yes, yes, yes. Scroll down a bit. Yes, that's it. If you can mark the last paragraph. Yes, thank you very much. Yeah. So, when we are assessing whether presumption is rebuttable or irrebuttable, we have to go a bit deeper and see what is the structure of presumption. Every presumption, whether it is rebuttable or rebuttable, has two main components. The first component is the ground for presumption, which is in Latin called basis, and the other is the consequence or presumed fact, which is in Latin called thesis. Regardless the presumption is rebuttable or is irrebuttable, it can always be contested on the level of basis. So, but the difference lies on the level of thesis, while a rebuttable presumption can be contested also on the level of thesis, the irrebuttable presumption cannot. And so let's see what is the structure of this presumption. It says, in case of termination of the agreement on sale of the capital property due to the failure of the buyer of the capital to fulfill the contractual obligations. This is the base, this is basis. This is the ground, first component of presumption. What is the presumed, what is the consequence, what is the thesis? The other part, the buyer of capital is dishonest party and shall have no right to refund the amount paid. So this is the structure of the presumption. And termination as a base of presumption is always rebuttable. I mean, it's not rebuttable, it can be contested. But the other one, hypothetically, imagine situation when the buyer does not want to contest termination. Can he claim payment of the purchase price, repayment? He cannot, because he cannot rebut either his dishonesty or consequence of non-payment of the purchase price. So that is, if you want, if that answers your question.
Thank you. Well, but I always thought that the idea behind the rebuttable presumption is that it cannot be rebutted.
Yes, it is the
So,
idea.
if you say that something is irrebuttable presumption, then you cannot contest it, you cannot challenge it anywhere, it has to stay by the force of law, correct?
That is what I already said, yes,
And
and
if
I
it's
agree with
a
that.
rebuttable presumption, then you can challenge it in some way before the court or by producing some document and change the situation, correct?
Yes, but as I explained, there are different ways to contest the presumption. Even irrebuttable presumption could be contested on the ground of basis. You have to contest the basis of presumption in order to clear the presumption, let's say that.
Okay, let's take a look at the provision that you quoted, and then you tell me what part of the provision is irrebuttable, that cannot be contested.
Okay, under assumption that the privatization agreement is terminated, it cannot be rebutted that the buyer is the honest party and that he has no right to refund the amount paid as a purchase price.
So, the irrebuttable part is the second part, right?
Yeah, the irrebuttable part is the second part.
Okay, and it kicks in if the agreement is terminated.
Yeah, it is. Yeah, that's correct.
Okay, and we have a situation in which agreement is terminated. That's it, right?
Yeah,
And
that's
then
it.
we go to the court and rebut that, and challenge the termination, and we
Yeah.
rebut the second part of the sentence that
No,
we are, sorry.
That is
we are-
not how
sorry,
it
can
works.
Can I finish?
Yeah,
Thank you.
sorry.
That we are dishonest, that we don't have the right to refund the purchase price, etc. So what is irrebuttable there?
Well, I will try to explain. Maybe I was not clear enough. This is not how it works. As I explained, basis, the grounds of presumption can always be contested, regardless it is rebuttable or irrebuttable presumption. The thesis cannot be contested. So if we are speaking hypothetically, let's see, the buyer, the privatization agency terminated the privatization agreement, and by its unilateral decision on transfer of shares, took over the shares of the buyer. The buyer and took the control of over the company, of course. The buyer wants to contest that, but then he decides that he doesn't want to contest the termination because the company is already under agency control. The litigation will last for 10 years until it finishes. He has no interest to return the shares. He wants to claim return of the purchase price. It is not, under this provision, it is not possible situation. He has to contest the termination in order to return the purchase price. And while contesting the termination, if he succeeds, he will get his shares back unless the company is sold. So that is, I'm trying to do it as simple as I can, but
Can I ask a clarification?
yes,
I
yes, Madam
understand
President.
that what you're saying is, as a buyer who received a termination, what I can do is say the termination is not valid.
Yes, that's
And
correct.
then the
Madam
rebuttable, the presumption does, the consequence, or what you call the thesis, does not kick in at all.
Yes, that's correct, Madam President.
And however, what I cannot do is accept the termination
Exactly.
and say, yes, but I'm not dishonest and please give me my price back.
Exactly, Madam President.
Obviously, if I challenge the termination and I'm right, then there is no termination, and then I cannot claim that there's no issue of returning the purchase price, right?
That's it.
That I stay in control of the company,
Yes.
unlike what you said just at the end.
Yeah, that's it. That's correct, Madam President.
Thank you.
Well, you basically say that the presumption is irrebuttable if the buyer does not do anything, but it is rebuttable if the buyer challenges it. Okay.
I think Madam President perfectly well understood and explained this. I do not understand. Can you just rephrase your question, please? I mean, I can repeat what I said, but I want to be helpful as much as...
Maybe I can restate it the way I understood it, and you will correct me if that's not right. What I understand the position is of the expert is that what you cannot do is challenge the consequence of a termination. You cannot say, I accept the termination, but I am not dishonest and I have a right to a repayment of the purchase price. That is not possible because what the expert says is that if the termination stands, then it has a consequence by operation of law, or automatic if you want, that you cannot reclaim the purchase price. And of course, you correct me if I did not understand what you're saying.
Yes, that was it. Thank you, Madam President.
Yes, I understood that, but then don't we have the same situation in many other, under many other provisions of contract law, that you have a situation when, for example, a buyer or whatever, a party to a transaction is presumed dishonest or in fault or whatever, and then that party can challenge that or change that in some way.
Let's ask this question.
Yes. Mm-hmm.
How would the provision read if the presumption were rebuttable?
Shall I answer to this hypothetical situation, take into the consideration, or just on theoretical level?
You can do it on a theoretical level first, at least.
Well, it would work in such a way that the buyer could contest could claim the amount paid as purchase price without contesting the termination.
So
If it would be irrebuttable.
So would it read like something the buyer of the capital is a dishonest party unless she proves the contrary?
Yes, that is correct. That would be the way. Yeah. And Mr. Jeric, if you want me to answer to your question that you have, which is related to civil law.
Well, we can follow up on this. And my question is very simple. Can the buyer prove the contrary under Serbian law?
Sorry, can you?
I'll say it again. Madam President said, and you agreed, that it would read like some, in case it's a rebuttable, it would read like something, quote, the buyer of the capital is a dishonest party unless she proves the contrary. My question to you is whether under Serbian law, the buyer can or cannot prove the contrary.
You mean in civil law relation according to the law obligation or something else? I don't understand that part.
In the context of this particular provision of Article 41A that we were discussing.
Maybe I did not understand you very well. Can you rephrase the question or ask me again,
okay.
Please?
I'll ask again.
Yeah, please.
Madam President asks you, how would the provision, and that is the provision of Article 41, last paragraph, how would this provision read if the presumption were rebuttable? And she offered to you possibility that it would read like, quote, the buyer of the capital is a dishonest party unless she proves the contrary. And
Yes.
then you agreed with that. That
Yes.
it would read, if it had read that way, it would have been rebuttable.
Yes, it would.
And my question is to you is whether under Serbian law, the buyer can prove the contrary, that he is not a dishonest party.
Well, it is completely different situation. It is provided in the Article 124 of the Law of Obligation and 132. In this situation, and why it's also important to emphasize that it is irrebuttable presumption, there are two phases. The first phase is appropriating the shares, restitution. In this phase, the agency rules the procedure where it terminates agreement and transfers the share. There is no way that the buyer could prove that there are no grounds for termination or that he or she was dishonest. He can just initiate litigation, would claim that the court declares that the termination was not valid and that the privatization agreement is still valid.
I'm not certain, I'm sorry for jumping in, that this is the question. The question, as I understood it, is do you need to have an express mention in a statutory provision of the fact that you can prove the contrary? Or can you, is it a matter of interpretation of the provision, whether it is the buyer is allowed to prove the contrary or not on the consequence?
Yes, I understand. In civil law, it is not required because it's completely different situation. The party who wants to terminate does not have authorization to unilaterally terminate and enforce termination. But it has to initiate litigation and then to prove the first step, and that is that there are grounds for termination. So it is not necessary to introduce such a rule.
Can I just add something to the mix? And I hate to complicate things further. Does it make any difference that 7.2 of the privatization agreement has a similar provision?
Just let me see, 7.2.
Yeah.
May I see that, please? Oh yes, that's just I mean, pasted provision of the Article 41A, which is in substance the same.
Right, but in one instance it's in the law, and therefore applicable differently than in an agreement. So I guess my question is, your explanation to Council's questions, is that changed by the fact that it's actually part of the agreement by the buyer?
It can be said so, but until the termination, but not through the step which is transfer of shares. I mean, unilateral transfer of shares. It is not under consent of the...
Thank you. So, sorry to interrupt.
Could you just, again, a clarification? The question from Madam President was, in the follow-up to my question was, do you need to have an express, I quote, do you need to have an express mention in a statutory provision of the fact that you can prove the contrary, or is it a matter of interpretation of the provision whether the buyer is allowed to prove the contrary or not on the consequence? And then you said, yes, I understand. In civil law, it is not required because it is a completely different situation. The party who wants to terminate does not have authorization to unilaterally terminate and enforce termination. Now, when you say in civil law, you are saying that is under the regime of the law and obligations, as opposed to the regime under the law?
Yes, I mean commercial contracts, yes, pure
Okay.
commercial contracts.
Okay, but under the specific regime of the law on privatization, the buyer could go to the court. He may not, the agency may terminate the contract without going to the court. We know that. That was the change of the law. But once it terminates the contract, the buyer can go and challenge the termination of the contract and rebut the presumption that follows, and which means that he is a dishonest party.
Well, it can, as I think we already discussed that, but I will answer. The agency will not only declare termination, but it will also decide on the buyer's rights before it can be heard. And transfer the shares.
That's a different issue, I'm sorry. I'm just asking
Yeah,
whether
okay.
the buyer can go to the court and disprove the whole thing. And
Yeah, it can go,
turn
but
the clock back, so to say.
yes, but that's again on the level of the basis of presumption, if we are talking about presumption, not on the level of that. Yeah, he can contest termination at the court, of course. And he can claim.
Okay, now if you could go to paragraph 46 of your second report. And you comment on Article 534.
Article 46, you said?
46, paragraph 46 of your second report.
Yes.
And you say, quote, Article 534 allows for pledges on BD Agro's assets if the pledges secure BD Agro's acquisition of funds, and then you quote the provision. BD Agro's acquisition of funds, quote, to be used by BD Agro. And,
Yeah,
and I submit to you, and we will now have to discuss it a little bit, this phrase to be, or this translation, to be used by BD Agro. Now, you say that this means that the funds are used by BD Agro when it loans the funds to third parties to grant the loan. Is that correct? That's paragraph 46.
Yeah, that's correct.
Yeah, okay. But if you look at the Serbian text of the privatization agreement, and that is the C-17, and perhaps, Madam President, we could have also translators, interpreters jump in to help us, or we will see whether the help is needed. So the Serbian phrase, the Serbian phrasing of the text is, it says, čiji će korisnik biti subjekt. So I would submit to you, so my translation from my head is, the user shall be the subject. And so it's not to be used by, but the user shall be. So the emphasis is on the subject, not on the verb, so to say.
Well, that
Do you
would be a
agree with
literal translation. Sorry, Mr. Jeric, if you want.
Sure, go ahead.
That would be a literal translation, that what you said, but the meaning is the same for me. It's not any different.
Well, okay, maybe we could say, hear what the translators
Yes.
have to say on this, whether the emphasis is on the subject or on the verb, so to say.
Why, can you please read the Serbian version, and then we have the translator interpret, and then we'll see whether we still have questions for them.
Kupac neće opteretiti hipotekom osnovna sredstva subjekta u periodu važenja ugovora, osim radi obezbeđenja potraživanja prema subjektu koja su nastala iz redovnog poslovanja subjekta, odnosno osim pribavljanja sredstava čiji će korisnik biti subjekt. Yes. Okay, we move on. Thank you for the clarification. Now, Mr. Milosevic, let's take a look again at the privatization agreement.
Okay.
That is C17, and if you could be so kind, would be so kind to look at the Annex 1 of the privatization agreement, which deals with the protection of the employees.
Okay.
Can you confirm to us that the Annex 1 is called social program?
To confirm what? Sorry.
That the Annex 1 of the contract is called social program.
Yes, I agree with that.
And can you confirm to us that in paragraph 2 of this annex, there is an obligation of the buyer not to unilaterally terminate the collective agreement with employees in the period of 2 years?
Yes, that says so. Yeah.
And then in the next paragraph, the buyer is obligated not to fire the employees in the period of 2 years.
Yes, it says so.
And now if we move on to the end of this, to the next page of this social program, and that is a page in the translation. It's page 9. It says there is a title, Protection of Union-Related Rights and Union Representatives. Now, would you agree that this obligation of the buyer is not limited in time, just according to the text?
I wouldn't agree. It has also in the scope of the Annex 1. Can you please return back to the start of the annex, if possible? So the annex and 41A, Article 41A, this cannot be applied longer than the last term of the privatization agreement. So whatever states here, and let's see what is in privatization. I mean, this was not a part that I have detailedly assessed in this manner. That's why I'm. Can we see Article 41A? No, it's in privatization agreement. Sorry, that part. It cannot last in any way above the term of the agreement. You are implying that it could last indefinitely, this provision, as I understand you.
No, I'm not implying. I'm just saying that this is not a provision that is limited by 2 years as other provisions that we mentioned.
Also, in that case, it cannot extend above the last term on main obligations or the other main obligations, which are under some time limit.
Okay. Now, in your second report, at paragraph 147, you discuss ombudsman's involvement.
Okay.
And you say that the justification for his involvement was, quote, clearly bogus. Is that correct?
Yes.
And then you say that the privatization agency and the Ministry of Economy did not have the task to protect the rights of the employees of BD Agro through their supervision. So therefore, the involvement of Ombudsman was not justified, so to say. Is that correct?
That is correct in the concept of the termination of the privatization agreement, yes. In that scope, yes.
Okay, but would you agree that at least as they are formulated, some of the rights in the Annex 1 of the agreement were still there?
Well, yes, but as far as I recall, the Ombudsman didn't grounded his interference just on the rights of the workers. He just informed the agency that they informed him that the agency did not terminate the agreement and it should be terminated for some other reasons. That's the field where the Ombudsman should not go.
Okay, if you take Exhibit CE 42, page 2, which states the reasons
Yeah.
of the Ombudsman's recommendation.
Give me just in Serbian, it will be faster.
It's the last document in the bundle.
Just give me a few moments to read it. I have reviewed this, but some time passed.
Please, could you read the first paragraph of the reasons at page 2?
Yeah.
Does it mention that the Ombudsman received a complaint from employees of company BD Agro?
Yes, I see that. And they are also stating below that they're having problems for quite a while, and that there were irregularities in fulfillment of the buyer's obligation as per provisions of the sale and purchase agreement.
Okay. Do they mention at the very end of that paragraph that you just started to read that the letter calls for termination of the sale and purchase agreement, and that the payment of salaries, taxes, and contributions that have not been paid since 2009?
Yes, they said that, yes.
So there are some rights that are allegedly, at least by this complaint, allegedly have been violated and have been subject or the reason for Ombudsman's control.
Yes, I do not dispute that his control was triggered internally a bit with that also. But there is also another part. It's in Serbian version, it's second. It should be fourth paragraph of the reasons. Just a second. Yeah, that was not initial one. Yes, actually, it's in Serbian version on the page 4. Can we see that part? Because it clearly shows
Which part do you refer to?
the one which is above the bolded part. It's I mean,
That's
if we
page
can
5 of
find
the
it, no,
English.
if we can find it in English version, so
That's page 5 of English version at the top.
yeah. The Ombudsman once, this first paragraph, the Ombudsman once again addressed the Ministry of Economy with an official document numbered that and that in order to find whether the process of supervision of the work of the privatization agency or privatization company was completed and which was the results with act as for from May and etc. etc. It explains what has been done in ministry supervision and what this is finishing with is the last sentence. The report ordered the privatization agency to send the buyer notification of an additional granted 90-day terms. So at the end, the Ombudsman is dealing with termination of the agreement, not on the grounds of violation of the Annex 1, but on the grounds of termination of other provisions of the contract.
Okay, but you agree that one of the triggers for Ombudsman's involvement was the letter of the workers that complained about the protection of their rights.
Yes, I agree with that.
And Madam President, this concludes our cross-examination. Thank you very much.
Thank you. Mr. Prakash, are there questions in redirect?
Yes, Madam President, I will have one question to clarify. Dr. Milosevic, you were asked questions about the social program attached in Annex 1 to the privatization agreement.
Yes.
And one provision there which did not state a time limit.
Sorry, can you repeat? I did not hear you well.
One provision in Annex 1 which did not state a time limit. Do you recall that?
Yes, yes.
And you were, then you asked Professor Jeric whether he implied that the provision applied indefinitely. He said he did not apply that. And if I remember well, you then answered that the provision in any event could not have applied longer than the main provisions under the privatization agreement. Do you recall that?
Yes.
When, in your opinion, did the main provisions of the privatization agreement cease to apply?
In particular case, with the payment of the last installment of the purchase price, because before that, all other terms has expired and all other obligations has been fulfilled.
And do you recall the date when it happened?
It was in 2011, but I do not recall the date. I would have to look.
Do you recall when the Ombudsman started his procedure? In which year?
No, I do not recall. I would also have to check. That was in 2015, I think, so, but I don't know exact date when it started.
Yeah. Thank you. I have no further questions.
Thank you. My colleagues have questions? Yes, please.
Good afternoon. I'd like to understand a little bit about the effect of court decisions on the privatization agency. So as the agency, it has the law and its regulations. What effect should court decisions have on the conduct of the privatization agency in how the court interprets the law?
In the case of termination and transfer of shares, if we are talking about post-2005 period, the court decision where the court awards the buyer, adopts the claim of the buyer, would hypothetically terminate, or sorry, not terminate, would declare the privatization agreement valid.
Oh, sorry, sir. I think I've led you astray. What I mean is that if the court says something about one case, how would the future conduct of the privatization in relation to other cases? In other
Okay.
words, does the privatization agency, oh, remember there was a case last week which said this, now we have to do that?
Yeah. Well, actually, the case law is not mandatory.
Right.
Because we are not common law system.
Yes, thank you. If we could put back up on the screen RE 166, which was one of those court decisions. And I noticed at the beginning of it, it's got what says dispositif. And then the final sentence of that in the English, which says, can be legally terminated due to the non-performance of only one of the contractual obligations assumed, comma, which is simultaneously an essential element of the contract. Now, in English, that could be ambiguous. It could mean only if it is simultaneously an essential element, or it could be which is always an essential element. I'm just wondering if the Serbian is any clearer as to how that final part after the comma conditions the part that came before the comma.
Yeah, this is cumulative condition. It has to be, the agreement could be terminated due to the non-performance of only one of the contractual obligations assumed if it is simultaneously an essential element. Yes, I think that it is correct translation of this.
Okay. If a breach of a minor and non-essential obligation were found, then in your opinion, termination is not a remedy. What is a remedy?
Okay. Which I think, Scout, I'm trying to not to go out from hypothetical situation and to think what would should happen here. You mean, by your question, you mean what could the agency do if determination existed, how they could act?
Yeah, so as I understand your testimony, if it is minor and non-essential, but is breached,
yes,
then in your opinion, it cannot be terminated.
Yes,
yes.
Yes.
So my question is then, what is the remedy for the privatization?
Okay, I understand you now. According to Professor Wisner, such breaches can lead to the damages.
My final questions are on...
I mean, damages claim, to be, sorry, to claim for the damages, that's
so the
meant.
privatization agency would have to be a plaintiff to claim damages, yes, okay, understood. If we go to your second report at 167 on the pledge agreement. Now, we heard quite a lot of testimony from the fact witnesses. I don't know if you had a chance to read the transcript or in the room during...
Some of them
okay.
Some of them I did not.
Yeah. Well, they talked about reciprocity and it was implied in the pledge agreement that it was side by side with the obligations. and then you give an explanation. You give 3 reasons why, in your opinion, the Article 122 of the Law of Obligations doesn't apply to this situation.
Yes.
And what I'd appreciate your help with is if we then pull up CE17, which is the privatization agreement. So they'll just show that to you at 11.1. And you see there, I don't know if you have it in front of you.
Provision
11.1.
11.1.
Yeah. And there it says that the following appendices shall constitute integral part of this agreement, and the share pledge agreement is therefore an integral part of the main agreement. So does that change any of your answers that you gave in 167 and onwards?
No, it does not change.
And why not?
We are talking about the share pledge agreement,
Yes.
and you are asking me whether it is mentioned as appendix change anything to my statements.
Yes, and that it constitutes an integral part of the main, the principal agreement.
Well, it is. It doesn't change its nature. I mean, usually it's referred in the practice to appendixes to as an integral part of agreement, and the nature and the purpose and everything that I said here does not change due to the fact that this is integral part of this main agreement. It doesn't make it main obligation or something. It is still accessory, which is there to provide security for the payment of the purchase price, which stems particularly either from the share purchase agreement, share pledge agreement, and also from, I think, Article 3.2.1 or something.
Okay, so following paragraph 169 of your second report, what you're saying is that the fact that it's considered an integral part of the main agreement doesn't change the fact that it is an accessory to the main obligation, and therefore
that's the nature.
Your opinion remains valid as it is in 169. Okay, thank you. No more questions.
Thank you.
Thank you, Madam President. Mr. Milosevic, if I understand well, if a payment of the purchase price of the privatization is made immediately after the conclusion of the privatization agreement is still in force for a period of 5 years. Is that correct?
The privatization agreement was in force for, I think, 5 years, and the purchase price was paid in installments.
But if it is paid immediately, the privatization agreement is still in force or not?
Sorry, I don't think I quite understand well your question.
If the payment of the price is made, say, immediately after the conclusion of the privatization agreement, is the privatization agreement still in force?
Yeah, it is, of course.
For which period?
It depends on particular other main obligations. There are positive and negative obligations, positive ones which are aimed that the buyer has something to perform in some granted term, and negative obligations were that the buyer should have performed in a certain way for the certain period. So if the payment of the purchase price was at the date of the conclusion, for example, of the agreement immediate, then still the buyer would be in obligation to in certain period of times fulfill other obligations like social program, like Article 533 to invest, and etc., all others.
So,
And that, the payment of purchase price in that case would not be the last obligation. In this case, it was the last.
so when can we consider that the privatization agreement is terminated? After the fulfillment of all obligations?
Maybe you don't want to say terminated, you want to say when does it end?
Yeah, when does
Exactly,
it-
yes.
yeah.
The question is, thank you, Madam President. See, my question aims at determining the moment in which the agreement ceases to be enforced.
Yeah, I understand you. After fulfillment of the last main obligation and expire of the last term, which has to be provided. That is for negative obligations.
Okay, thank you. So if the agreement ceases to be in force and one of the parties consider that one of the provisions of the agreement was breached by the other,
Okay.
what happens? Is it possible to raise the question?
Well, in the case that the buyer doesn't perform and fulfill the last main obligation which is left, then it could terminate. But if the buyer performs the last main obligation without remedying the breach of the one which is purport to secure that main obligation, then the accessory obligation, ancillary obligation, loses its purpose after fulfillment.
Yeah, but my question was in relation to, say, a discovery that one of the provisions of the privatization agreement was not fulfilled. The provisional agreement has ceased to be in force. Is it possible to raise the question of the breach of this obligation, even if the agreement is no longer in force?
After, in some situation, hypothetical situation, it is.
Yes, yes, I'm speaking in a general manner.
Yeah, generally, there
on the basis of Serbian law. That's my
yes, there are some
idea.
prolonged obligations in certain situations.
And I suppose, I'm not a specialist in Serbian law for sure, I suppose there will be kind of prescriptive terms in Serbian law, like in many other domestic legislations. There are prescriptions for actions.
What, sorry?
Statute of limitation.
Yes, sorry.
Yes,
statute of limitation is the better translation. Yes. Yeah, okay. And I suppose that the statute of limitations is different with regard to administrative or with regard to private actions. Obviously, in civil law, in criminal law, there must be different statute of limitations.
Actually, it depends. It does not necessarily. Statute of limitations in the law on obligations and the general law, which prescribes the statute of limitation, only make differences between court judgments as a single category under special provisions, but it does not make any difference on administrative acts or administrative relations in particular.
Okay, thank you.
Unless it's prescribed by the special law, some special law.
Thank you. Another question. I understand that the foreigner cannot make a bid in a privatization auction.
Yeah, sorry, I did not maybe hear you.
I'm sorry,
well.
I will
I'm
try
sorry for that.
to speak louder. I understand that a foreigner cannot make a bid in a privatization auction.
Foreign investor cannot make a bid. No, I think in the period which was relevant, I guess the foreign investor could make a bid for privatization agreement. There was a legal possibility for them. I mean, that was not restricted for foreign investors.
It was not only for Serbian.
No, it was not only for. Actually, the explanation, one of explanations, I think from 2005 exactly, explains that the privatization is aimed to provide foreign investments, for example. So yeah, it did not restrict foreign investors to.
So during the period which interests us, a foreign investor could have participated in the privatization of BD Agro directly. This is what you say.
Yeah, they could participate.
Okay, thank you. In your first expert report in paragraph 29, yes, in paragraph 29, the second sentence, you referred, I read it, the 2001 law on privatization also articulated other basic principles of privatization, such as transparency, flexibility, and the sale of the privatized assets at the market price.
Yes.
How do you reconcile the idea of transparency with the distinction between a nominal owner and a beneficial owner?
Yeah, I see. Well, actually, the principle of transparency is aimed to the agency to provide transparent procedure of privatization. It is not aimed to buyers. The buyers are not those that has to be transparent unless the agency requires them to do so.
Okay. Yes, another point. So if I understand you well, the provisions for termination in privatization agreements would be considered like a lex specialis and then would prevail over Article 41A of the law of privatization. This is what I understood. Is it correct? Or
not necessary. I would not put them in such relation. It will not prevail. I mean, it does not prevail over the law. It cannot prevail because the law provisions are mandatory. It just provides specific meaning where it is possible. So the Article 41A, paragraph 1, item 3 provides that the buyer cannot dispose with the property contrary to the agreement. So that just points to the agreement, and the parties just give specific meaning to that provision and determining which disposition and how would be prohibited.
So does it mean that both coexist?
Sorry, but
does it mean that both the provisions of the law and the provisions of the agreement coexist?
Yeah, they coexist.
Okay. Yes.
Can I just ask a clarification,
Yes,
if you
please,
don't
of
mind?
course.
They coexist, provided to the extent the privatization law refers to the contract.
Yes, exactly, Madam President.
Thank you. So do you consider that the provision aiming at securing the fulfillment of the substantial obligations are essential or not essential?
I guess that I presume you're meaning the Article 534 or?
No, I'm talking in general. I'm talking in general. I'm not talking specifically on this privatization agreement. So in general.
In general,
yes.
Provision which provides security for fulfillment of the main obligation usually is accessory obligation.
Accessory.
Yes, unless stipulated otherwise.
You refer that in the period 2001-2003, the law of privatization in force at that time did not contain any provision on termination of agreements. This is what I understood?
Yes, you understood me well. Before 2003, which means the version of the law from 2001 did not provide special provision on termination, with the grounds for termination.
Does it mean that the new legislation that followed was more restrictive with regard to the possibilities of termination?
Well, yes, in the meaning that the legislator has started to introduce mandatory rules in 2003, and it also broadened its scope in 2005. I mean, broadened the list of the reasons for mandatory termination, yes.
So during the period 2001-2003, what was employed in order to decide about termination was the law of obligations.
Yes, it was the law on obligations and provisions of the particular contract. That was.
And does it mean that the law of obligation is more liberal, so to speak, compared with the law of privatization that followed?
Well, it's general law. Law on obligation is general law, while law on privatization is special law. That would be that.
But what I mean is it easier to terminate a contract between two persons, you and me, for instance, than a contract of like a privatization agreement?
Privatization agreement. Well, actually, there was not much difference before amendments in 2005, but after these amendments and after after the agency was given the power to unilaterally transfer the shares from the buyer to itself or to a share fund upon unilateral decision, well, then it was much easier to terminate and to effectuate termination, which is even more important. To terminate agreement is quite easy even in civil law, but to effectuate termination is what requires time. In this case, the agency was able to effectuate termination and to appropriate the shares at the same day when it terminates the agreement.
Okay, thank you. I have a legal curiosity, Madam President,
Yes,
with your permission. The law of obligations of the Socialist Federal Republic of Yugoslavia is still applied in Serbia and the other states of issued from the former Yugoslavia.
Yes, it still applies in Serbia, and I think most of it is still applying in Slovenia, Bosnia, Montenegro, I mean, everybody applies that law because it's very well, it was very well prepared.
Thank you. Thank you very much. No
Thank
further questions, Madam President.
We have been dealing with the question of the duration of the privatization agreement in a number of ways. But I was struck when I read your reports. If you go, for instance, to your first report, paragraph 65, and then you, do you have it there? You said the privatization agreement imposed numerous obligations upon the buyer for various periods of time, but in no event for a period longer than the term of the privatization agreement, which term expires upon payment of the full purchase price. And you say this in various other places in your reports. Now, today I understood that the position was a little different, right? Because what I heard you saying today, and you will correct me if that's wrong, is that it is the payment of the full purchase price and the performance of any other principal obligation.
Yes, that's correct, Madam President.
And that is principal obligation, whether it is a positive or a negative obligation.
That's correct, Madam President.
Yeah. The difficulty we have with this contract, of course, is that it has no provision on term or maturity date or expiration date.
Well, yes, that's why it requires interpretation, but the term, the final term of the agreement, by my opinion, should be assessed while assessing the terms of every particular obligation. So every one of them has some term on its own, and the last one, which lasts for the longest period, is payment of the purchase price in installments. So, by my opinion,
Yeah, in theory, it would be the longest one is the 5 years for the payment of the purchase price. Now, as we have discussed, there could be other fact situations where this is not the last one. But yeah, I understand your point that it's the performance of the last principal obligation.
Exactly, Madam President.
It's still related to this. In paragraph 73 and 74, still in your first report, you say the same thing, that you could not terminate after full payment of the purchase price. Now, I understand this needs to be somewhat nuanced, but then you say the existence of such time limit, which I understand the full payment of the purchase price time limit, was confirmed by the appellate court, and then you have a quotation. I don't read this quotation to say this.
I will explain. This is not related to the term of the particular obligations. This is related to the term of the agency's control and performance. And this case law wants to emphasize, and what I wanted to emphasize here, that with the expiry of all obligations, of all main obligations, the privatization agency is not entitled to control anymore, because that is the moment when the company becomes private company. So it's
so that is what
that's what.
Yeah, good. you have this position that you've explained in several of your reports, that even if there had been a ground for termination, legally the termination would not have been proportionate. And I
Yes.
have been asking myself, the proportionality test is one that comes more from public law. And what is the relationship between proportionality on one hand and your distinction between minor or
Yes.
accessory principal obligations and minor breaches? Is this not just a different way of saying the same thing?
Yes, it is different way of saying the same thing, but I had to provide that assessment because this is not simple commercial contract, and that it has also elements of commercial relationship, but also the elements of administrative relationship. And in regards to the elements of administrative part of this relationship, I thought that it would be useful to make also the proportionality analysis.
There's a discussion in your second expert report that is triggered by the opinion of Dr. Radovic, and it's in paragraph 112 and following. About whether the termination has de lege effect or whether you need to give a notice. Do you have it there?
Yeah, I have it there, Madam President.
It's also on the screen right
Yeah,
now.
just give me just a second, please, to remind myself what was that about. Yes. The main, let's say, reason for which we do not agree, I'll try to give the example. In civil law, there is also termination ex lege. It's the Article 125 of the law on obligation. 126 is basically the same method. One party shall notify the other party on a breach and leave additional deadline, and if that party does not comply, the contract shall be terminated. So that is also ex lege. But the effects of termination, even they are ex lege, cannot be performed by themselves. So in civil law, the party which wants to terminate agreement will initiate the court proceeding. In this case, the agency will bring the decision to transfer shares, which is necessary for effectuation. That is not just the note, as Mrs. Radovic implies, or just declaration. This is decision which effectuates the termination.
Yeah, so it's linked to this kind of quote-unquote self-enforcement mechanism.
Yes.
Yeah. Good. That has made me ask myself whether you say here that the law on privatization did not provide for the maximum number of additional deadlines but the agency could give. And I've asked myself whether it is admissible that the creditor of an obligation after a breach, makes no decision for a long period of time about whether it wishes to terminate or not, assuming it is entitled to terminate, does it have an obligation to at some point say, now it's too much, now I stop? Or can it go on and on? Now, I understand that it can give additional deadlines, but does that not at some point end?
Yes, well, the law does not provide such limitation, but it is reasonable to interpret it in such a manner. There is also some case law which is provided on this issue, which opines that until the expiry of the terms of the main obligations, the control powers of the agency shall be fulfilled and stopped. It could not control it, further. But in the practice, in this case, the agency could indefinitely postpone provide additional deadlines if it interprets that this is correct. I mean, there was nothing that the buyer could do to prevent that.
Yeah, I can understand. I can see that this is not problematic if you have a company that is making profits, because then you can say for this time the owner does collect the profits. If it's loss making and the owner invests more and more into it, is it then still admissible that you wait?
Well, it should not be for the. You mean for the agency? Is it
Yes,
admissible?
that the agency waits,
Yeah,
or
by my
any
opinion,
creditor in this
Yeah, yeah.
same situation.
By my opinion, it would not be admissible, nor proportional.
Yeah, that's your other answer. At the beginning of your examination, cross-examination, you were led to the law on money laundering, which is 800 C867, and there's an article 3.4 with definition of person under foreign control. And you said that trust exists under Serbian law. I understood you to say this, but
Yes.
then I have a little trouble following you considering the wording. Now, at the same time, I'm asking myself, there are jurisdictions where trusts do not exist as a legal construct, yet there is a recognition of foreign trusts and of certain, at least certain of its, of a foreign trust's effects. Is there such a recognition under Serbian law?
I'll just maybe it would be more helpful to check the paragraph 9, where I have defined what did I presumed as the beneficial ownership, because I'm not international law expert nor any common law.
Okay, fine. Then maybe that's not a question for you. I
Yeah,
should ask it.
I
to
had to
someone.
define it. Yes, it's.
Thank you. No, I have no further question. So, Mr. Milosevic, thank you very much for
Thank you,
your
Madam President.
explanations.
Madam President,
Yes, is there
no
a
opportunity
clarification?
for clarifications this time?
Sure.
I'd like to have one.
Sorry. Maybe it's just because I think that everybody's hungry.
Yeah.
So.
Oh, I am
But
hungry.
of course,
Yeah.
you're
My professional obligations come first.
No, I agree.
Mr. Milosevic, you were asked some questions about principal positive and negative obligations under the privatization agreement with capital P, capital A, so the privatization agreement we are talking about in this case. Just to clarify, is the obligation set out in Article 534 a principal obligation or not?
No, it is not a principal obligation.
And were there any principal, whether positive or negative obligations that remained to be fulfilled under the privatization agreement after payment of the last installment of the purchase price in April 2011?
No, it was not any remaining main obligation to be fulfilled.
Thank you.
Thank you. Fine. So this now ends here. Good.
I beg your indulgence, just a small clarification from the expert. In line with what Mr. Vassani has asked, I believe this was his first question, are regarding Exhibit RE 166. So and you asked about the first paragraph of the English and the last sentence of that and what is the meaning. If the witness can clarify that this, what says here, dispositive, is not a ruling, but actually a summary of the text of the court decision which follows under the inverted commas afterwards.
Yes, I can confirm that the part which is labeled dispositive is not a ruling, it's someone's summary of what is below.
Sorry, can I just, when you say someone's summary, is it not the court's own summary of its decision?
It could be court associated, it could be even judge, it could be redactor.
Okay, because I would note that I don't see essential element of the contract in the actual decision. I do see it in the dispositive.
Yeah, exactly,
Okay.
yes.
Thank you.
Thank you. So now this ends your examination. Thank you for your help.
Thank you very much.
Let's take the lunch break and resume at 2:15. Is that fine?
Alors, je ne sais pas pourquoi on appelle ça dispositif.
C'est pas un dispositif, c'est
Sommaire.
un sommaire, oui.
code.
We ready to start again? I should say if there are attendees in the other room, then I would like to greet them, because when we sit here, we tend to forget about them, and I don't know whether the Canadian representatives are also attending on Zoom. If so, they're welcome. Professor Grujic, is that your name?
Yes, that's correct.
Thank you. Your first name is more difficult, but maybe it just looks difficult. Ujesha?
It is difficult, yes. So it's Uglesha Grujic.
You pronounce the G, Uglesha.
Yes.
Yeah, good. So for the record, you're Uglesha Grujic.
That's correct.
Thank you. You're a professor at University College London.
That's correct.
Were you-
Associate professor.
Yes, I dropped the associate. Where you teach, among other areas, private international law.
Yes, private international law is my core discipline.
Thank you. And you've written 2 reports in this arbitration, the first one of the 3rd of October 2019 and the second one of the 5th of March 2020.
That's correct.
You're heard as an expert witness. As an expert witness, you must make only statements in accordance with your sincere belief. Can you please confirm that this is what you intend to do by reading the expert declaration?
I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you. So I will first turn to Claimants Council for initial questions, and then we will go to Serbia's council.
Madam President, we have no questions.
No questions. Then Professor Dudris.
Yeah, it's even more difficult. It's Jundic.
Say it again.
Jundic.
Jundic.
Yes.
It's not that difficult.
Wow. Thank you, Madam President. Good afternoon, Professor Grujic.
Good afternoon.
Thank you for being with us here. I have some question, obviously, for you. And I would like to start with the issue of the law applicable to the MDH agreement. So I will try to paraphrase your conclusions, and you will tell me if I'm right or not. You claim that the MDH agreement is governed by the law of British Columbia, either by the way of express choice of law made subsequently by Mr. Obradović and Mr. Rand, or as a result of the tacit or implied choice of law. Is this correct?
Yes.
So in paragraphs 23 and 24 of your first report, You state that an express choice of law can be made at any time, not only after the time of conclusion of the contract in question, but also subsequently. The chosen law applies from the outset, from the moment the contract was concluded. The only limitation is that the rights of third parties should not be adversely affected. So, your position is that, your understanding is that such choice was made by Mr. Rand and Mr. Obradovic in their respective witness statements in this arbitration. This is paragraph 24. Is this correct?
Yes.
So the witness statement that you referred to and that contain the subsequent agreement on the applicable law were drafted and signed in October 2019. Is this correct?
As you can see, it's not mentioned in this paragraph. So this is what I have been instructed.
Right. This is, for the record, this is Obradovic witness statement, second witness statement, paragraph 15, and Mr. Rand's witness, second witness statement, paragraph 19. So, according to Mr. Rand's second witness statement, if we can have it here, paragraph 56. The Serbia agreement replaced the MDH agreement on 22nd February 2008. That is, MDH agreement was terminated on the same date. Is this correct?
I see what is written, yes.
Okay. So to clarify, is it your position that parties to a contract that ceased to exist in 2008 can choose law applicable to the contract in 2019? Although the contract in question does not exist anymore.
So my position is that the parties to a contract can select the applicable law subsequently.
Even though the contract is, I would say, dead and buried for 11 years.
Yes.
Okay. So, two parties, MDH from the one side and Mr. Obradovic from the other, they choose the applicable law, the law of British Columbia, in the arbitration in which Mr. Rand is one of the parties, or rather one of the claimants, against the Republic of Serbia.
Madam President, I will object. This is a misrepresentation of the content of the two witness statements.
I
witness
believe
statement-
that Professor Grušić is here and he can answer for himself. This
Well,
is
but
indeed.
no, I maintain my objection.
Yeah, we would have to go to the witness statements because I don't have them present now in my mind. Let's go to
Well-
Mr. Rand's second statement, paragraph 56, quickly.
If I may, this is only to confirm what has not been disputed so far, and this is that the MDH agreement was indeed terminated when the Serbia agreement was concluded.
I understand this.
No.
I didn't understand this to be the issue. I understood your question is about whether one can select the applicable law to a contract when that contract has ended,
Yes,
right?
this is my question.
It's an interesting question.
Madam President, if I may explain the basis for my objection, is
Yes,
that
please.
the question was not asked in the abstract. It insinuated that the choice of British Columbia law was made only during the time of this arbitration, and that is not in accordance with the content of the witness statements of Mr. Obradovic and Mr. Rand. I can take you to these provisions. They
Well,
state
if-
there
if-
that it was their understanding from the beginning when this agreement was
if
So
signed.
they articulate, they express a past implied choice. Is that what you're saying?
Well, I believe their testimony is that it was their understanding at the time in 2005.
Yeah, but it was not written, so it was an implicit
Oh, okay.
choice made in the past.
Yeah, correct. Yeah.
would you want to comment on this?
Yes,
Not in terms of facts, but in terms of
Yeah, so my
law.
conclusion was that the parties to the MDH agreement made a tacit choice of British Columbia law when the contract was concluded. And I was also advised that the two parties, Mr. Rand, who signed the contract, and Mr. Obradovic, said that they both understood that at the time they made a contract which was subject to the law of British Columbia. And I did say that the parties to a contract can subsequently also agree on the applicable law.
Which is not what they have done here if
They have
we
not done.
follow what Mr. Rand said.
So there was no change of the applicable law. The applicable law was the law of British Columbia, and we have witness statements where they confirmed that they operated on the assumption that the contract was governed by the law of British Columbia. So there's no change of the applicable law, if that's what the other, Mr. Jundic is suggesting.
If we can both agree that there was no explicit choice of law, then we can move on.
I believe that the parties to a contract can make an explicit choice at the moment of court proceedings or at the moment of arbitration. In this particular case, the parties have made an a tacit choice at the moment of entering the MDH agreement, and they have confirmed in their witness statements that this was the assumption on the basis of which they were operating at the time.
I see. So this is basically, your statement is given in general terms and not in this particular case. There is no express choice of law.
The parties to this contract made a tacit choice.
I see. Thank you. So moving to the tacit choice of law under the MDH agreement. So in your report, you rely on several different factors that were identified by the Serbian Higher Commercial Court in its 2006 decision to support your conclusion of the existence of tacit choice of law for the MDH agreement. This is Claimants Exhibit 446.
Can you please refer me to my witness statement when I say this?
Yeah, this would be section 3.2.3 of the first report.
You refer to a specific court decision from 2006. Can you refer me to the part where I mentioned that court decision? Because I don't know by heart whether it was made in 2006. So I just want to see it.
I can project it for you at the screen. So this is Claimants Exhibit 446. Yes, this is it. Can we see the bottom of the?
Could you please refer me to the part of my statement where I say that this is the case law on which I'm relying for this particular proposition?
Yeah, this is the paragraph 21 of your expert report. Serbian courts have confirmed on many occasions that the party's choice of law can be made expressly or tacitly. This is footnote 8. For example, the Higher Commercial Court held in its decision of 1st September 2006, and then you go on and list different factors that serve as indicators of the so-called implied or tacit agreement. So going back to Claimants Exhibit 446. So in the paragraph starting with, however, it is a slippery slope between, there is a list of those factors. Now they are highlighted for us here. So my idea was to ask you to go with me through some of these factors for tacit agreement on the choice of law. So the first one would be choice of court. And parties did not insert a choice of court clause in the MDH agreement. Is this correct?
Yes.
The other one is use of standard form contracts or general conditions of business based on the law of a particular country. So this criterion does not point to any particular national law. Is this correct?
So when you say the other one, you're referring to the third factor listed here?
Yes.
Yes, so I understand that this wasn't a standard form contract or based on certain general conditions of business.
Thank you. So the next one is agreement on a common place of performance or conclusion of the contract. So according to your report, and that would be paragraph 31 of the first report, there is no common place of conclusion of the contract. Mr. Obradovic signed the contract in Serbia and Mr. Rand in Canada. Is this correct?
That's what I was instructed.
You also state that the agreement did not specify the place of performance. And that, I quote for paragraph 31 of the first report, it is clear that some obligations arising under the contract, the payment obligations and negative obligations, do not seem to be limited to any particular territory. Is this correct?
Yes.
So what about Mr. Obradovic's obligations under Article 5 of the MDH agreement? So if we could see CE15, the text of the MDH agreement. So, as you can see here, there are Mr. Obradovic's obligation to vote any shares held by him from time to time at any shareholders meeting of the company in accordance with instructions received from the purchaser being MDH. The seller, meaning Mr. Obradovic, further agrees to cause the board of directors of the company to consist of those parties nominated or agreed to by the purchaser and to keep the purchaser advised from time to time of all communications received by him as the registered owner of the shares. The seller shall follow the instructions of the purchaser with regard to the management of the company and shall use his best efforts at all times to enhance the value and income of the property. So would you agree, would it be fair to say that the place of performance of those obligations is Serbia?
No.
Even though Mr. Obradovic resides in Serbia and BD Agro's place of business is Serbia?
There is no geographic limitation in this provision of this particular obligation. And I understand that Mr. Obradovic is a Canadian citizen.
So geographical limitation would exist only if Article 5 would stipulate that those provisions must be, or those obligations must be done in Serbia, Serbian territory.
I wouldn't speculate, but in this particular provision, there is no geographical limitation. I can agree that this is a Serbian company, but there is no geographical limitation of this particular obligation.
I see. Okay. So another criterion is common nationality of the parties. To clarify, your position is that parties to the MDH agreement have common nationality. Is this correct?
No. My position is that Mr. Obradovic, I was instructed, is a dual national. So he's a Serbian national and a Canadian national.
Right.
The other party to this agreement is a company called MDH, which I understand is incorporated in British Columbia, but has an office in, incorporated in British Virgin Islands, but has an office in British Columbia. And Mr. Rand, who is a director of the company, he is a Canadian national who resides in British Columbia.
Well, wouldn't it be correct to say that according to Serbian rules of private international law, Mr. Obradovic would be considered as solely Serbian citizen?
This is an international contract, and
agree.
Mr. Obradovic is a dual citizen of Canada and of the Republic of Serbia. And I believe that the Serbian court would take both of these factors into account.
But in this particular issue, in determining the nationality of parties, Serbian court would take into account its Private International Law Act. Am I right?
Yes.
Can we go to Respondents Exhibit 315? So this is the Serbian Private International Law Act. For the tribunal, I should probably state that this is the act. This was the old federal Yugoslav Act of Private International Law that was inherited by Serbia and still enforced in Serbia. So any reference to Yugoslavia or Yugoslavian citizens should be read as Serbia or Serbian citizen. Can we go to Article 11, Paragraph 1? It reads, if a person who is a Serbian citizen also has the citizenship of another state, he shall be considered for the purpose of application of this law to have solely the Yugoslav, that is Serbian citizenship. Is this correct?
That is what the provision says.
Thank you.
But I also believe that when determining the law governing a contract, especially the tacit choice of the law governing a contract, a Serbian court would take a holistic approach and would consider all the relevant circumstances of the case. And in this particular case, Mr. Obradovic was a citizen of Canada, as well as the Republic of Serbia. And there's a number of other factors which point to the application of British Columbian law. So on a holistic approach, the Serbian court would have to conclude that the law of British Columbia governs the contract.
Well, the formulation holistic approach sounds somewhat mysterious. I mean, would you care to explain, does this mean that the holistic approach suspends the application of Private International Law Act?
What it means is that there is a number of factors that the Serbian court will take into account when determining the applicable law.
Sorry, would you like to through those factors?
Would you let me finish? You asked the question. So when you look at the contract, you will see that the parties clearly use certain terms which are peculiar to common law countries. And British Columbia is a common law jurisdiction. So they refer to terms such as beneficial ownership and some other terms which clearly suggest that when this contract was drafted, the parties had the law of British Columbia in mind as the applicable law. And that is the main factor, I would say, for reaching a conclusion that this contract was governed by the law of British Columbia. The fact that Mr. Obradovic is a Canadian citizen is also relevant, but I would say that that's a less important fact.
So out of 7 factors listed in this higher commercials court decision, you would submit that the one that you just mentioned is more important than the others?
I do think that the use of the terms in this particular contract that are a peculiarity of common law countries clearly suggest that they had the law of British Columbia in mind. And that is also something that is confirmed in the witness statements.
I see. So if we can go back to the said decision, Claimants Exhibit 446. Page 1, third paragraph from the bottom of the page. This is precisely the same paragraph, starting with, however, there is a slippery slope between it, meaning the tacit choice, and the hypothetical party autonomy. It should not serve to the court only to achieve the application of its own law as the governing law. It is therefore necessary that the indications of a tacit agreement by the parties are beyond any doubt, that they can convince the court that the parties have reached an agreement. the last sentence of the same paragraph. One should not lose sight of the fact that the basic feature of party autonomy is that it removes uncertainty about the applicable law. So it would not make much sense and be justified to engage in exploring a choice that gives rise to controversies, different interpretations. So do you agree with the statement made by the higher commercial court here?
Do you agree with the statement? I agree with what is written here, that there is a number of factors that ought to be taken into account in order to determine whether the parties have made an implied or a tacit choice of law. And what we can see in this particular contract is that the parties agreed that one party will give consideration of $10. We can see that they mention certain concepts that are peculiar to common law systems, such as trust, beneficiary equitable ownership. We can also see that they use the time shall be of the essence clause. And I believe that it is beyond doubt that the parties had in mind the law of British Columbia when they made this contract. And that
So
is also what they testified. They said that they had in mind the law of British Columbia when they made this agreement.
So you are saying that there are no factors pointing to Serbian law in this contract, in the MDH agreement?
Could you repeat the question?
You are saying that there are no factors which point into the direction of Serbian law at the MDH agreement?
What I'm saying is that the parties in this particular case agreed, they used certain terms, they used certain concepts which basically make sense in the context of British Columbia law.
Professor Grušić, I think you made your point. I see what you mean. So if we can move on. Another high commercial court decision, or those are rather answers to questions from commercial courts that you use in your report. This is Claimants Exhibit 448. And this is, for your reference, your report, paragraph 23. The last sentence in the 6th paragraph of the decision. You can see it on the screen. It reads, "It is essential that the indications used to draw a conclusion as the parties' tacit consent are infallible and convince the court that an agreement was reached." So what I meant to ask you basically is this: when you consider these decisions, would you agree with me that the indications for the existence of implied choice must be clear and unequivocal? In general terms, of course, I understand your position.
So in this particular case, the parties used terms beneficial owner, consideration, trustee, $10 consideration, times of the essence. To my mind, this convinces the court and should convince this tribunal as well that the law governing this contract is the law of British Columbia. And moreover, the parties expressly mentioned in the witness statement that this is the law that they had in mind.
So I thought that we all agree that this is not an express choice of law, what they mentioned in their witness statement, because it would amount to the express choice of law in this arbitration.
What I believe I said is that the parties to this contract made a tacit choice of law in favor of the law of British Columbia. And also the parties to a contract can make an express choice of law after the contract was concluded.
Thank you, Professor Grušić. Tell me, does Serbian private international law accepts the doctrine of proper law of the contract?
Could you repeat the question?
The Serbian private international law accepts the doctrine of the proper law of the contract.
In this particular case, we are dealing with a situation where the parties selected the applicable law in a tacit way. So I'm not entirely certain.
Do you know what the doctrine of the proper law of the contract is?
Yes.
So can you explain it for us?
The doctrine of the proper law of a contract is a common law doctrine. It is applied traditionally by the English courts and many other common law courts, but I'm not sure that this is what I'm supposed to talk about here today.
Thank you. So moving on to the law applicable to the Serbia agreement. The law applicable to the agreement is law of Cyprus, according to your report. I believe that this is your understanding. Is this correct?
Yes. Because the parties expressly agreed at the time of conclusion of the contract that the law of Cyprus will govern.
So is it correct to state that the chosen law governs the contractual relationship between Serbia and Mr. Obradovic? To clarify, I mean that the law chosen by Mr. Obradovic and Serbia does not govern the relationship between Serbia and the privatization agency. Is this correct?
I'm sorry, I'm not sure I understand your question.
Well, my question is that the law chosen by Serbia and Mr. Obradovic has inter partes effect, meaning that it governs the contractual relationship between those two parties and don't have effect on a relationship between Serbia and the privatization agency. Is this correct?
The Serbia agreement is governed by Cypriot law.
Is it correct to say that in Serbian private international law, the law chosen for the contract does not govern the effect that the contract might have on the property?
Could you please specify your question, make it more specific?
Is it correct, if you want me to specify my question to be the most precise question that I can give? The law chosen as the applicable law for the Serbia agreement is the law of Cyprus. The law of Cyprus, which is chosen for a contractual relationship between Serbia and Mr. Obradovic, has proprietary effects on the shares of BD Agro.
Could you please define what you mean by proprietary effect?
I mean defining the moment in which the ownership is acquired on those shares.
Could you please specify what you mean by ownership?
Maybe, can I try this? Does the law that governs the contract extend to property issues?
So my understanding is that this contract is governed by the law of Cyprus, and that under the law of Cyprus, it basically transferred beneficial ownership to Mr. Rand.
If I may ask, you were giving your reports on issues of Serbian private international law. Is this correct?
Yes.
So my question concerns the effect of the chosen law based on rules of Serbian private international law.
Yes.
So would you care to answer to my question then?
So I
on
understand.
the rules of Serbian private international law, does the law chosen for contractual relationship affect at the same time and proprietary? Does it have the proprietary effects?
Again, could you please define what you mean by proprietary effects? In this particular case, the Serbia agreement is governed by Cypriot law. And I understand from the witness statement, expert witness statement given by the Cypriot lawyer, that the effect of the agreement is to create some beneficial interests in Mr. Rand. And I believe that Serbian law would recognize these rights, beneficial rights that Mr. Rand acquired.
Okay, so Serbia, let's say, buys a certain stock of shares in BD Agro from Mr. Obradovic. The parties agree that the applicable law for their contract, their mutual rights and obligations, is Cypriot law. The Cypriot law determines the exact moment in which the ownership in those sold shares transfer from Mr. Obradovic to Serbia. That is my question, and I was hoping I'm going to get the answer that concerns the rules of Serbian private international law.
Again, could you please be more specific? I'm referring to a legal
I don't
title.
think I can, Madam President, I don't think I can be more specific than this.
No,
could I-
let's take it a little, one step after the other. You're saying that the law of the contract creates, under the law of the contract creates beneficial ownership.
That's what the Cyprus law expert
Yes,
says.
right, and that's your premise.
Yes, that's my premise, exactly.
And so is this beneficial ownership, if I look now from the standpoint of Serbian private international law, a matter that I characterize or qualify as a property right issue or a contract right issue?
So unfortunately, I don't think this particular matter is settled in Serbian law. So
Well, how do you see it?
yes, how I see it, I believe that there is a gap in the law, in the Serbian Private International Law Act. So there is simply not a choice of law category for trusts, foreign trusts or beneficial ownership. And that in situations like this, a Serbian court would find that there is a gap in the law and would apply Article 2 of the law, which deals with gaps in the law. And according to Article 2 of Serbian Private International Law, gaps in the law are to be filled by taking into account the principles of Serbian legal system in general, the principles of the Private International Law Act, and the principles of comparative private international law. And I believe that two principles in particular. One is the principle of in favorem negotii, and also I believe that it's a principle of comparative private international law to recognize at least certain effects of foreign trusts. So having these two principles in mind, I believe that Serbian law would recognize rights created under Cypriot law.
Thank you.
Yes, I was going to get to the issue of recognition of trust in Serbian private international law, but since Dr. Grušić already raised the issue, I'm going to ask a question with regards to Article 2 of the Serbian Private International Law Act that you just mentioned. So this is, as you said, a provision that serves the purpose of filling the gaps in Serbian choice of law rules. Am I correct?
Yes.
So this is not the rule of Serbian substantive law. It does not determine rights and obligations of the parties. It is just a rule that should help the court determine the applicable law.
It's a rule that is found in Article 2 of the Serbian Private International Law Act, and it deals with situations where there are no provisions in this law on the applicable law with respect to a relation that falls within the scope of the Act.
So just for the ease of convenience for the tribunal, can we see Claimants Exhibit 874? This is Article 2. So this Article 2 basically says that it obliges Serbian courts to come up with a choice of law rule if and when faced with a dispute involving foreign trust, and not to give substantive law effect to all or some of its aspects. Is this correct? Does it sound accurate?
So this provision says that if there is no provision concerning the law applicable to a relationship of Article 1, the provisions and principles of this Act, the principles of the legal order of the Republic of Serbia, and the principles of private international law shall be applied accordingly.
Well, I would say that probably my question was not clear enough. I would need to specify once more. So this provision will help Serbian court to determine, to formulate a choice of law rule when there is no one in the Act. Is this true?
This provision is meant to help a Serbian court to deal with a situation where there is no provision concerning the law applicable to a relationship from Article 1, Paragraph 1 of this Act.
So you agree with me? basically. But it does not say that, for example, beneficiary of a trust has a beneficial ownership in shares in joint stock company, does it?
I think that there are two principles that should be taken into account. So one is the principle of in favorem negotii. So if you have two parties that enter into an agreement that is governed by Cypriot law, and the agreement is valid, and under Cypriot law, the effect of the agreement is to create certain beneficial rights. I think that the principle of in favorem negotii, which is a principle of Serbian law, would mean that from the perspective of Serbian law, those rights would be upheld. And I also believe that that is a principle of comparative private international law.
Yes, so this principle in favorem negotii, that means in favor of transaction, does it apply when the rule of the foreign law is in contradiction to the overriding mandatory provision of Serbian law?
Overriding mandatory provisions apply to legal situations that fall within the scope.
Yes. My question was, if this transaction that a court should favor to keep it alive, let's say like that, if this transaction is contrary to Serbian overriding mandatory rule, then this principle in favorem negotii does not apply. Is this correct?
No, I don't think it's correct. I think what is correct is that an overriding mandatory rule applies to situations and only to situations which fall within their scope.
Thank you, Professor Grušić. You also state that comparative, and you mentioned that just earlier, private international law shows that trust should be recognized. This is paragraph 99 of Professor Grušić's second report.
Sorry, could you repeat what paragraph are you referring
99.
to? 99.
This is the last sentence. Comparative private international law shows that trust should be recognized at least for some purposes. And there's a footnote 67. And there you explain that the Hague Convention on the law applicable to trust and on their recognition demonstrates that the principle of recognition of trust, or the principle of comparative private international law, is that trust should be recognized. Is this correct?
At least for some purposes.
Yes, at least for some purposes. So is Serbia bound by this convention?
No.
So you speak about the fact that many common law and civil law countries are or accept this convention, and this fact should be taken into account when determining what comparative law position is.
What I say is that if there is a gap in the law, a Serbian court will apply certain principles. Amongst those principles are principles of comparative private international law. And I believe that Serbian law would not invalidate foreign trusts very easily, and that it would give recognition to foreign trusts, at least for some purposes. And I believe that that is in accordance with general principles of private international law, and those principles are reflected to an extent in the Hague Convention.
Understood. But you also say that the comparative law, or the acceptance of these principles of your position in comparative law, is demonstrated by the fact that many civil law and common law countries are contracting parties of the Hague Convention, mentioned in paragraph 67. Is this correct?
So there are many countries that are parties to this convention.
How many?
Excuse me?
How many countries?
I don't know by heart.
So does it number of 10, for example, sounds?
I don't want to speculate.
Okay, thank you. So going back to the issue of overriding mandatory provisions under Serbian private international law. In your first report, and that is paragraph 76, you accept that certain provisions of Serbian law listed here can be regarded as overriding mandatory provisions under Serbian private international law. Is this correct?
I accept that these 4 provisions mentioned here are overriding mandatory provisions.
Understood. In paragraph 65 of your first report, you explain the 2 main characteristics of those mandatory provisions, overriding mandatory provisions. We can just see that, yeah. They are regarded by the country to whose legal system they belong as crucial for safeguarding its public interests, such as its political, social, or economic organization, and they apply to any situation falling within their scope without regard to the law determined as applicable under the relevant choice of law. So, my question is, if there is a conflict between the law applicable under the choice of law rule, the general choice of law rule, and some overriding mandatory provision of the form, this would entail that the overriding mandatory provision must be applied. Is this correct?
An overriding mandatory provision applies to situations that fall within the scope of the provision.
Thank you. Paragraph 27 of the second report. You state, my opinion was and still is that any provision of the MDH and SEMBI agreements that were contrary to an overriding mandatory provisions of Serbian law could not be effectuated in Serbia. But the consequences of any such conflict for the validity of the MDH and SEMBI agreements are to be determined under the law governing these agreements rather than Serbian law. And you support this statement by saying also in paragraph 27 of the second report, there is an agreement in Serbian private international law that the issue of validity of a contract is subject to the law applicable to the contract. Is this correct?
Yes.
However, I would submit to you that this is the general rule as well. The law chosen for the contract applies subject to certain exceptions. For example, the law chosen for the contract does not apply if it is in contradiction to public policy or overriding mandatory rules. Is this correct?
My position is that the law governing a contract applies to the contract to different issues, including the issue of validity. However, if there is an overriding mandatory provision and the situation falls within the scope of the provision, then the overriding mandatory provision applies.
Thank you. Paragraph 29 of the second report. You state that, I quote, it is accepted in Serbian legal theory that the concept of overriding mandatory provisions must be interpreted narrowly because the application of overriding mandatory provisions of Serbian law to contracts governed by foreign laws should be an exceptional event. An expansive application of domestic overriding mandatory provisions would undermine the Serbian system of private international law, which is in principle based on multilateral choice of law rules and in the field of international contracts on the principles of party autonomy and the closest connection. I would like only the second part of the paragraph to be highlighted. Thank you. So you, when citing this or when stating this, you refer to a Serbian textbook on private international law, which is contained as Claimants Exhibit 454.
Yes.
Can you see it? 4. 454, C 454, page 390. So Professor Grušić, I would like you to take your time and to identify the exact paragraph of this textbook in which the citation or the language that you, the formulation that you refer to is contained. Let me remind you, an expansive application of domestic overriding mandatory provisions would undermine the Serbian system of private international law, which is principally based on multilateral choice of law rules and in the field of international contracts on the principles of party autonomy and the closest connection.
So my position is that the Serbian system of private international law, so choice of law rules, are based on multilateral rules. And we can see that from the Private International Law Act, because it doesn't actually mention the concept of overriding mandatory rules. So that implies that the law applicable to a relationship is primarily the law that is determined on the basis of the multilateral rules contained in the Private International Law Act.
I understand.
Sorry, would you let me finish?
I would like you to answer my question.
Yes, I'm answering your question.
I must disagree.
Also I believe it is also uncontroversial that Serbian law recognizes the concept of overriding mandatory provisions. And I think it is also uncontroversial that overriding mandatory provisions apply to the extent to which the situation falls within the scope of the overriding mandatory provision. And I also think that it is uncontroversial that because the Serbian system of private international law, its choice of law rules basically, its choice of law system is based on multilateral choice of law rules, that exceptions from this, that is the application of overriding mandatory rules, should be an exceptional event, and that consequently overriding mandatory provisions should be applied restrictively. I believe that this is supported by paragraph 734 of the textbook that you refer to. So if you read after the comma on line 3, the application of overriding mandatory rules, so such an approach carries with it the danger of protectionism and gives rise to considerable legal uncertainty for natural and legal persons involved in international transactions. This authority, namely the authority to apply overriding mandatory rules, may very easily be exploited and may lead to an unwarranted extension of the application of national law. I believe that these two statements support my what I wrote in my report, namely that the application of overriding mandatory rules is an exception to the system of private international law in Serbia, which is based on multilateral or bilateral choice of law rules, and that consequently overriding mandatory rules should be interpreted in a narrow fashion.
So let me try again. You submit that the concept of overriding mandatory rules must be interpreted narrowly. This is your position. And then you cite a part or a page or a paragraph of Serbian textbook in private international law. And you say, an expansive application of domestic overriding mandatory provisions would undermine the Serbian system of private international law and so on. Can you point the tribunal to the exact wording of this text?
Such an approach carries with it the danger of protectionism and gives rise to considerable legal uncertainty for natural and legal persons involved in international transactions. This authority, namely the authority to apply overriding mandatory rules, may very easily be exploited and may lead to an unwarranted extension of the application of national law.
It could be that we have different understanding of the same text. I mean, yeah.
I believe that these two sentences that I read from the textbook basically say that the application of overriding mandatory rules is an exception to how the Serbian system of private international law should work. And in order to avoid the danger of protectionism and an unwarranted extension of the application of national law, overriding mandatory rules should be interpreted narrowly.
So where do you find precisely this formulation? An expansive application of domestic overriding mandatory provisions would undermine the Serbian system of private international law, which is principally based on multilateral choice of law rules and in the field of international contracts on the principle of party autonomy and the closest
Madam
connection.
President, I would object. The question was asked 3 times. I believe it was also
I
answered.
think-
Well, it was not answered 3 times, Madam President.
What I understand is that the textbook doesn't use these words and doesn't say exactly that.
That is correct,
But
yes.
Professor Grujic understands the dangers of protectionism and expanding too much the application of national law that is addressed in the textbook to be reflected in his statement. Now, you may disagree, of course, but that is what I understand.
Yes, yes. Thank you, Madam President. I would like us to stay with this page 390 of the Claimants Exhibit 454. In the middle of the paragraph 734, it says, sight should not be lost of the fact that under this approach, the court is left to assess whether the mandatory provisions of national law are of such nature that they may be construed as mandatory regulations directly applicable to case with a foreign element. So would you agree with me that the authors of the book, they warned Serbian courts about dangers of identifying just any provision of Serbian law as mandatory, overriding mandatory rule?
I'm not sure I understand the question, sorry.
This particular paragraph warns that not just any provision of Serbian law may be identified as overriding mandatory rule. Is this correct? Is this your understanding of this highlighted text?
So my understanding is that Serbian courts decide which provisions are of an overriding mandatory nature. And my understanding is that the application of overriding mandatory rules to relationships governed by foreign law is an exception, and that the Serbian courts should be wary of the danger of protectionism and unwarranted extension of the application of national law, which means that they should not interpret domestic overriding mandatory provisions expansively.
Well, here, the authority that you rely on basically say that courts should be cautious in identifying rules of Serbian law as overriding mandatory provision. But they do not say that once identified as such, those provisions must be interpreted narrowly. Am I right?
I believe that Serbian courts need to take into account the system of private international law, which is based on multilateral choice of law rules. This is an exception to how the system works, and in order to avoid the dangers of protectionism and unwarranted extension of the application of national law, Serbian courts should be cautious and should interpret overriding mandatory provisions in a restrictive way.
A restrictive way.
Narrowly, restrictively.
So, yeah. So there is a contract which, with a choice of law clause identifying foreign law as applicable. And under that applicable foreign law, the contract is valid. On the other hand, you have Serbian overriding mandatory rule. And by application of that Serbian overriding mandatory rule, the contract is null and void. Which of those two would be applicable?
That's a hypothetical question. If you're referring to the facts of this particular case, we
I'm
have
referring.
we have contracts that are governed by foreign law. And we do know, I believe this is not contested, that Article 2 of the MDH agreement, for example, could not have been effectuated in Serbia because it was contrary to some overriding mandatory rules of Serbian law. The possibility to effectuate a legal provision in a situation like that would be assessed under the Serbian overriding mandatory rule, but the validity of the contract would be governed by its applicable law,
So
which is
basically-
foreign law in these cases, in relation to these two contracts that we are dealing with.
So basically, when you say that the consequences of Serbian overriding mandatory rule would be assessed based on the law applicable to the contract, you mean that in this question that I asked, which is the general question, principal question, when you have a foreign law applicable to the contract and by which the contract is valid, but you have Serbian overriding mandatory rule by which the contract is invalid, in your assessment, this would mean that Serbian court would apply the foreign law. Am I
That's
right?
not what I said. I said that if a contractual provision cannot be effectuated in Serbia, cannot be performed in Serbia because it is contrary to an overriding mandatory provision, then this fact will be taken into account and the validity of the contract will be assessed under its governing law. In this particular case,
Thank you, Professor Grufic.
in this particular case,
Thank
the
you.
contracts are governed by foreign law. And the fact that one of the contractual provisions could not have been effectuated, performed in Serbia, would be taken into account as a fact under the relevant applicable laws.
So you're saying that Serbian court, by application of its private international law, would give effect to the MDH agreement. Is this your position?
I believe so, yes. Well, it was, sorry, the Serbian court would not give effect to Article 2, but it would find that the MDH agreement is valid.
Would it consider that the MDH agreement transferred the ownership in BD Agro shares from Mr. Obradovic to MDH?
Could you please define what you mean by ownership in this question that you asked?
In this question,
Yes.
I mean ownership under Serbian law.
Are you referring to legal title in shares?
I'm referring to the right of ownership.
If
Serbian
you're
law.
referring to legal title, then the answer is no.
Thank you. So, I understand that you are an expert in issues of private international law.
Yes,
Would you say
that is my
the-
primary field.
Yes. Would you say in the main areas of your interest are, I would say, English and European private international law,
And Serbian as well.
Serbian as well? So in your second report, in particular, you comment on the validity of the MDH agreement and the SEMBI agreement under the rules of Serbian contract law.
That is
So
correct.
would you consider yourself an expert in Serbian contract law as well?
In the parts of her report, Professor Mirjana Radovic referred to certain issues of Serbian substantive contract law, and I was instructed by the Council for Claimants to address those issues.
Well, that was not exactly my question. My question was, would you consider yourself as an expert in Serbian contract law?
Define expert.
Well, I will. Have you published any works in this field?
In the field of Serbian contract law?
Substantive contract law, yes.
No, I haven't.
Do you have an extensive experience as a practicing lawyer dealing with the issues of Serbian
I
contract
practiced law in Serbia for 3 years, and I have dealt with many contracts under Serbian contract
So
law.
when was this?
Apologies?
When was this?
So I practiced between 2005 and then 2008, roughly. And then afterwards, I worked at the Faculty of Law at the University of Belgrade for 2
Thank you.
years.
So this is, yeah.
And I also, I'm regularly engaged by clients to give opinions in cases like this on Serbian law.
Thank you, Mr. Grušić. Thank you, Madam President. This concludes Respondents' Cross.
Thank you. Any questions and redirect, Mr.
No
Petraš?
questions, Madam President.
Any questions from my co-arbitrators? Yes, please.
Good afternoon, Professor Grušić.
Good afternoon.
I have a question concerning issues of nationality. Indeed, I have two questions concerning issues of nationality. So on the basis of the documentation you received for this case, if you have to determine the prevalent nationality of Mr. Obradovic, what would you say?
So if you were to apply a choice of law rule from the Serbian Private International Law Act and the connecting factor is nationality, then it would be Serbian nationality of Mr. Obradovic that is relevant.
Irrespective of the Serbian law on private international law. Put aside the Serbian law on private international law, and on the basis of the information you have, what would be, in your view, the prevalent nationality of Mr. Obradovic?
I haven't been instructed to give an answer on that question. I don't think I can give it on the spot.
Well, this is a question I'm raising. Just you may answer or not if you're right, of course.
I really apologize. So if you're asking me if a Serbian court were to apply a choice of law rule from the Serbian Private International Law Act, and that provision of the Serbian Private International Law Act uses the connecting factor of nationality, then I think Mr. Obradovic's Serbian nationality would be relevant.
Yeah.
But I'm not sure I can opine on anything other than that.
I think maybe the prevalent or effective nationality test is more a public international law issue than a private international law one. So.
Okay. My second question also concerns the nationality of MDH. If you have to determine the nationality of MDH, what would you say?
Under Serbian private international law.
Give your answer.
So under Serbian private international law, the starting point would be the place of incorporation, but also maybe some other factors might be relevant. So sometimes another country might be treated as the country of nationality if certain requirements are met. But I have to say that I haven't been instructed on this, and I don't feel comfortable giving an opinion on the spot.
Okay, well, that was my question. But, okay, well, thank you.
Professor Kuzic, when you were taken to Article 5 of the MDH agreement, let me go there. So it's C15. Can we just show it on the screen? Yes, here it is. You said there's no geographical limitation, or you said limitation, but there's no geographical indication in this wording. And you said this, I think, but you have to tell me, because you were applying the different factors for determining whether there is a tacit choice of law. And one of the factors is whether there is an agreement on the place of performance. Is that right?
That is correct, yes.
Yeah. But that is because we're in the exercise of the tacit choice. If we now were, for one reason or another, to consider there's no express choice, there's no tacit choice, and we go over to what in French I would call rattachement objectif, which is just looking at the effective closest connection closest connection test, then I would consider consider these factors and with others, of course, but if this is one connection, isn't it?
Yes.
Or these are connections.
Yes. So if on the assumption that the parties didn't make a choice of law, then there is Article 20, which deals with the law that governs the contract in the absence of party autonomy. And there is a possibility to take into account basically all the objective connecting factors to determine the applicable law.
And that would include, well, in part the same factors like those you would include for tacit choice, but it would
Yes.
also include the actual place of performance of the obligations envisaged in a contract. Is that right?
Yes.
And that would be Serbia. That would point to Serbian law. I'm not saying we would end up with Serbian law, but that would be an element in favor of Serbian law.
I'm not actually sure that it would be, because when I look at Article 5, we are obviously dealing with a Serbian company.
Yeah.
But I'm not sure where the bodies of that company necessarily sit.
Assume they sit in Serbia.
I haven't been advised on the composition of the board of directors. I'm not privy to how the decisions or where the decisions are made.
Is the fact that we're dealing with a Serbian company not an element pointing towards Serbian law?
That would be a relevant element.
There may be countervailing
that would be a relevant element,
elements,
yes.
right? Yeah.
Yes.
Let me see whether I have other questions. Did I understand you correctly about overriding mandatory provisions, that your point is if there is one, first you have to identify it and identify that you're within its scope and that it seeks to capture this fact situation?
Yes, so I think there are several steps that have to be taken. So one is to check whether a particular provision is an overriding mandatory provision or not. Then I think the next step is to look at the scope of the provision to determine what is the scope. The temporal scope of the provision, I think that's quite important with respect to some of the provisions that we are dealing with here, but also the subject matter scope. And then the third step would be to see whether the facts or the circumstances of the particular case fall under the scope of the overriding mandatory provision.
Yes, and then this mandatory provision, if it does apply, may apply to parts of the contract or to the contract as a whole.
Correct.
Yeah. And how do I know whether a mandatory overriding provision is a mandatory overriding provision?
That's a good question. I think that's the holy grail, in a way, of private international law. One indication might be to look at the introductory provisions of the Act. So there are some acts which specify their geographic scope. So that would be, I would say, an easy way out. But
many do not.
Apologies.
Many do not specify their scope.
Many don't specify. Then it's a question of interpretation.
Yeah. Would it be right to say that what determines whether it is an overriding mandatory provision is whether the provision wants to apply itself to a certain,
yes,
to the extent that a provision can want something?
Yes, that's correct. So in some cases, the Act specifies its geographical scope, and that indicates that the provision of the Act wants to be applied to facts that take place within a certain territory. If there is no indication of that kind, of that nature, then it's a question of interpretation to what extent the scope, if you will, reaches, the provision reaches.
Fine. So I think I have no further questions. And if there's no follow-up clarification needed, then I would like to thank you very much, Professor Grisic.
Thank you very much.
Let me look at the time. Now it's 3:30. We understand that Mr. Dean is available starting at 4 o'clock. Is that right?
This is correct, yes.
So I think we have no choice but to have a break of half an hour. Yes. You don't want, are we impliedly saying that we will not start the examination of Dr. Radovic today, or what's the view?
Well, I think that it will be better that we start examination of Professor Radovic tomorrow morning. If
I would not be able to finish the cross-examination of Professor Radovic today, so I think it would not be fair to her to have her in Perda for the night.
Yeah. Let me just see how it looks tomorrow. Yeah, I mean, that was the plan in any event, so I don't think that should be an issue. And then we have two other experts, but they're not as long, I would say, so that should be doable. Good. Then let's resume at 4 o'clock. We ready? Yes? Good morning, sir. Did you hear me when I speak?
Yes, I can hear you. Can you hear me?
Yes, perfectly well. Excellent. Thank you for being with us so early in the day. For the record, can you confirm that you're Robert Dean?
Yes, I am.
You're a partner at Borden Lardner Jervis?
Borden Ladner Gervais. Yes, correct.
Good. You have provided us with one written report that was dated the 3rd of October 2019. Do you have it there?
I do have a copy before me.
Is it an unannotated copy?
It is an unannotated, clean copy of the report, yes.
Thank you. Are you alone in the room from which you testify?
Yes, I am the only one here.
And you have no communication information sources other than the video conferencing platform on which we communicate now?
That's correct.
No smartphone or no open tablets?
No,
Laptop?
nothing.
Good. You heard as an expert witness, you're under duty to make only statements in accordance with your sincere belief. There will be a declaration now shown that will appear on your screen. Can you please read it loud into the record? Or does it, or you have it?
I have a copy with me, so perhaps I can read
Excellent,
that.
that's even easier, yes.
And so I'll begin. I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you. And you also know that if you're asked questions about specific documents, we will show them by sharing the screen. If you want to see more of the document, scroll up, scroll down, you just tell us.
I will do so.
Good. So let me first turn to Claimants Counsel.
Thank you, Madam President. We do not have any questions.
No direct questions. Then I turn to Serbia's counsel, Professor Djundjic.
Close enough.
I'm improving.
Thank you, Madam President. Good morning, Mr. Dean.
Good morning.
My name is Petar Djundic. I'm counsel for respondent, and I have a couple of questions for you, I would say. So to start, some of those questions concern the issue of the law applicable to the MDH agreement. So in paragraph 48 of your report, you start your analysis, your choice of law analysis, by stating that the first necessary step in the choice of law process is characterizing the issue under consideration. Is this correct?
That's what I say in paragraph 48, yes.
Yes, in paragraph 49, you explain, I quote, "The matter under consideration is best characterized as one of contract, given that the fundamental question relate to the effect of the MDH agreement, and the MDH agreement is concerned with the parties' rights and obligation in respect of intangible property, that being the BD Agro shares and other contractual rights under the MDH agreement. Correct?
Correct.
But in paragraph 71 of your report, you state that the MDH agreement contemplated that MDH would acquire ownership of shares in a Serbian company. Thus, the MDH agreement could be characterized as dealing with ownership of foreign movable property. Is this correct?
That's what I say in paragraph 71, yes.
So if this characterization would be accepted, then the law applicable to the MDH agreement would be Serbian law. Is this correct?
It's not that simple. You can see in paragraph 71, I refer to that proposition as one of the factors that may be said to support Serbian law being the proper law of the contract. No one factor is dispositive. In paragraph 71, when I say that the MDH agreement could be characterized as dealing with the ownership of foreign movable property, that is one characterization that one may advance as being one factor that would lend credence to the suggestion that Serbian law is the proper law of the contract. As you know, my conclusion and my judgment is otherwise.
Thank you. So moving on to those factors listed in paragraph 70 to 74 of your report. Now, those are factors supporting Serbian law being the proper law of the MDH agreement, correct?
Yes, those are factors that one would rely upon as pointing the court to the direction of finding that Serbian law is the proper law of the contract.
So I noticed that you left out the place of performance of the contract as a factor. Would you agree that the place of performance of the contract is one of the factors that were listed in the Imperial Life Assurance case that you rely on in your report?
The place of performance is one of the factors. Of course, it's an open question here where the MDH agreement would in substantive terms be performed. But certainly what I want to make clear is that in assessing the proper law of the contract, and at this stage, sir, we're assessing the question of the real and substantial connection or whether there is an implied choice of law. A British Columbia court would not restrict itself to a series of watertight compartments. It would take into account all of the factors surrounding the contract to come to its best judgment as to what is the proper law. One of those factors may indeed be the place of performance, however that is defined in the particular case.
So can we go to Claimants Exhibit 15, that is the text of the MDH agreement? So you'll notice in Article 5, there are some obligations taken upon by the seller, meaning Mr. Obradović. Would you agree with me that most of those obligations, the place of most of those obligations is Serbia, him being Serbian resident and BD Agro being Serbian company and having its all business activities in Serbia?
Well, I would need more facts. I mean, it refers to shareholders' meetings of the company. Perhaps those would be in Serbia. Even presumably those might be in Serbia. There refers to conduct of the board of directors of Serbia. Presumably those may be in Serbia. They may not be. But certainly the management of BD Agro, I think one would safely conclude, would involve contacts with Serbia, of course.
Thank you. So in paragraph 91 of your report, apologize. You characterize rights obtained by MDH through MDH agreement as, I quote, quintessential rights of the controlling shareholder of a corporation in British Columbia. correct?
Correct.
Would you agree that the right to receive dividends is also one of those most fundamental rights?
The right to be eligible to receive dividends is one of the rights of a shareholder of a corporation in British Columbia, yes.
So does the MDH agreement contain the right of MDH to receive dividends stemming from BD Agro's shares?
I don't recall. I don't have the agreement in front of me, but I do not recall.
Would you like for us to show you the text of the agreement?
I don't recall sitting here whether it refers to the right to be eligible to receive dividends. And I'll leave it up to council to determine what I should be shown.
Thank you. So according to your instruction, has MDH ever received any dividends based on its supposed ownership of shares in BD Agro?
That was not one of the facts I was instructed to assume.
Thank you. Moving on, in your report in paragraph 100, so you basically explained that the MDH agreement resulted in Mr. Obradovic holding BD Agro shares as a constructive trustee of a substantive trust, correct?
That's what I say in paragraph 100, a substantive or institutional trust in respect of the BD Agro shares.
I see, thank you. So am I right to say that the constructive trust may be imposed by the court only if certain prerequisites are met?
No. There are at least two types of constructive trusts in Canadian law and certainly in British Columbia law. One of the types of constructive trusts is what is known as a remedial constructive trust. A remedial constructive trust, as the name would suggest, is a remedy that the court can impose, the court can find, based upon certain prerequisites being established. Those prerequisites are generally those applicable to unjust enrichment in Canadian law, a deprivation and enrichment with the absence of juristic reason. A substantive or institutional trust is different from a remedial constructive trust. It is not a remedy, but rather a trust that arises in a circumstance where, for example, one assumes an obligation to hold property for the benefit of another. It's not remedial, and that's the distinction that I want to draw.
So remedial being, I was hoping you will help me understand. Being remedial means that it must be imposed by the court.
When I'm sorry, go ahead.
Yeah, unlike substantive trust that arises automatically from the contract. Is that the difference?
Well, I don't want to say it would be imposed by a court because under our theory of law, the court finds rights that exist, but it is a remedy that is found to exist in circumstances, particularly of unjust enrichment, and where a party has received property to which it is not entitled to receive, that it is not entitled to receive. British Columbia law, provided certain prerequisites are established, will allow a remedial constructive trust to be found, or to use your word, imposed, on the party holding the property at the time. That's different from the substantive or institutional trust I'm addressing in paragraph 100.
Can you explain the difference?
A substantive or institutional trust is not necessarily a remedial trust, but rather arises by virtue of a relationship. And the relationship typically is one where one assumes an obligation to deal with property that one owns for the benefit of a third party. So it's not intended to remedy a legal wrong. It is a trust that arises as an incident of a relationship.
Thank you. Thank you, Madam President. That concludes Respondents' Cross. Thank you, Mr. Dim.
Thank you, sir.
Any questions and redirect on the claimant
No
side?
questions, Madam President.
No. Do my colleagues have questions? I do not think I have questions either. Let me just check. No, I don't. So, Mr. Dean, that was fast. Thank you very much for being available and for your assistance. And that would conclude your examination. So you can either stay with us or leave the Zoom meeting. Thank you.
Thank you. I will leave you to your work and I will depart. Thank you.
Thank you. Goodbye. So that leaves us now. What do you want to do?
Well, I
we
think we
just-
have an agreement, right, that we would just wait until tomorrow morning in order to avoid putting Professor Radovic in isolation for the evening.
Is this
Yeah, that is correct. Yes, that's correct.
fine? Then enjoy the rest of the afternoon, and we'll. The sun's out. Yes, absolutely. Mr. Jared, you have a point.
Yes,
that you
one
want
short
to
point
raise?
of housekeeping. I'm sorry to have to raise it. Madam President, as you know, in big arbitrations as this one, there are many exhibits and some exhibits become cursed, so to say. And it seems to me that our demonstrative exhibit number 2, RDA 2, which was already corrected, will have to be corrected again. And it's again to the benefit of the claimants. Something was wrong with the calculation. It was calculated on 100% of the company. The tax was calculated, and it should have been calculated only for the part owned by Mr. Obradovic. So we are going to be uploading a revised and I hope final exhibit. And I trust that the claimants experts will have sufficient time to consider it before their examination, if they wish to consider it. So
Remind me what the
that's a
exhibit
tax.
is.
That's a calculation of the capital gain tax under Serbian tax
Yeah.
law.
Yeah,
So it's relevant basically for Tuesday.
yeah. That
Thank
should
you.
not be a problem. The experts will have enough time to
Yes,
look at
we
it.
agree.
Yeah. Anything else on the respondent side? No? Anything on the claimant side?
Sorry.
We are thinking, yeah, just we would need some guidance. How do you envisage tomorrow's hearing, which is starting at 9? So there are 3 expert witnesses, 2 of which may not be that long, 1 of which may be very long. Professor Radovic probably will be long, I expect. But perhaps we could work from 10 onwards, or we could
I
think of-
suspected you would say that.
No, but we
yes.
could, yeah. But we just wanted to be ready. Whether you have any other, considerations for tomorrow, nothing else.
Any considerations on the side of the
Yeah,
claimants?
just to
What
explain
you-
my non-verbal communication with Professor Jeric over the break, I suggested that we might inquire whether Mr. Papadopoulos, who is the first witness on Monday, could be available tomorrow. But then I was advised by my colleagues that that was not a good idea on my part to make that inquiry. I mean, my colleagues within my team, not my
Yeah.
friends across the aisle. Therefore, we would not suggest to cross-examine 4 experts tomorrow rather than just the 3 which are scheduled. As to the starting time, frankly, we probably have no preference, but since it's Saturday, it might be interesting to have a longer Saturday night rather than a longer morning on a Saturday.
These are very
yeah.
personal preferences, yes. If you ask me, I'd rather start late. But no, looking at the Monday, it's true that the Monday is relatively full, was all, at least according to your initial estimates, rather longer cross-examinations, while tomorrow is somewhat shorter. So we're in your hands. If you feel it is safer to try and advance Mr. Papadopoulos, if at all possible, then we could also try to have him tomorrow.
Well, we will go along with the claimants, so we don't have a, we are not insisting, and we think that with Professor Papadopoulos, we think that we should just go along with the schedule and have him on Monday.
On Monday, yeah.
I will appraise Mr. Anway of your comment, Madam President, and see whether that has an impact on his preference for Saturday versus Monday. But yeah, the only aspect which makes me wonder is that Mrs. Ilic will be testifying in Serbian on Monday, which may make it a bit longer. But on the other hand, I understand that she will be able to read documents in English that I put to her.
And I have found the parts that were interpreted fairly efficient, frankly. It worked well, so I don't think that's a major concern. No, the concern was rather than I see that Mr. Grzic is a rather long witness and Mrs. Ilic is a rather long witness as well, but you have been pretty much within your estimates or below your estimates, so shouldn't be a real concern. Should we leave it as it is planned, simply?
I think in that connection, it will be also determinative to some extent how much time the tribunal would like to have on Tuesday for potential questions.
Yeah, we have thought about this, and without having a definitive position on it now, because we need to rediscuss it, it seemed to us that what we will probably do on Tuesday is rather articulate what we expect for the post-hearing briefs. And that will be more efficient than asking you to improvise answers to questions on which you, in any event, will write again in the post-hearing brief. So it's more for us to try and define what are the areas, or there may be specific questions, but it may also be just areas where we would like you to focus in the post-hearing briefs without having to repeat the entire case. So that shouldn't take too long. We should have, if we have part of the afternoon, that's fine. And if we can close a little before the end of the afternoon, it would be appreciated. It will give us a little time to have a final discussion.
So would it be fine if we plan to end the crosses at, let's say, 4 p.m.?
Yes,
or
I would say
earlier?
no later than that, but that should really be doable, no?
Yeah, this should be doable. In that case, I think there's no need to move Mr. Papadopoulos from Monday to Saturday. That was the reason for that inquiry.
And it's also better to have both damages experts, one after the other. Any comments on your side?
Not really. We would stick with the schedule as you indicated.
Yeah, I think
Yes.
so. Let's, we have a schedule that works well, so let's just apply it. Good. Then I wish everyone a good end of the day, and we see each other tomorrow at 9. That's what I understood, or at 10? At 9. Okay, good. Fine. That closes the hearing for now.